Ready? Yep. Okay. Good morning, everybody. I would like to call to order the City of West Palm Beach Code Enforcement hearing for October 21st, 2020. My name is Keith Davis. I'm the special magistrate appointed by the city to preside over today's hearing. Before we begin, if you're going to be staying in the room, if you have any cell phones, please silence them so they don't interrupt our proceedings. Due to limited seating availability, I know the city's staff will be coming and going, but I'd like to go ahead and swear everybody in now, and then just as your cases come up, you can come and go. But as to anybody else who's in the room, if you're going to be speaking to me about anything on our agenda, I do need to have you sworn in as well. So if you're going to be speaking to me about anything on today's agenda, please stand and raise your right hand, and I'll swear everybody in together. Thank you. Do each of you swear or affirm under penalties of perjury that your testimony today will be the truth, the whole truth, and nothing but the truth? Thank you very much. Those of you who are remaining can have a seat. Folks who are going to be stepping out, feel free to do so. As we proceed through the agenda, the city will be calling cases, I believe, in the order that folks who are here signed up. We'll take those cases in turn. For each case, I'll hear from the city's staff first. There will be testimony, and there should be probably photographs and other documents that you'll be able to observe on the screens. Once the city's concluded its presentation, you'll have an opportunity then to tell me everything that you feel is relevant about your case. If you have additional documents or additional photographs that you would like me to look at for your case, that will be the time to show them to me. For the respondents who are present, when your case is called, you can come up to the podium to my right, and the city will be presenting from the podium to my left. I think that covers all the preliminary matters, so why don't we go ahead and get started.
Matter number 23, CE 2005-0009, 807 North Flagler Drive.
Do we have Mr. Belisle here this morning?
Matter number 61, CE 2008-0112, 2030 East Parkway.
And sir, we'll get your case as soon as the inspector gets back in the room. And,
Can't do either. That is having surgery before. You get it work. It's on here.
all right, are we going back to 23? Okay.
Sure. Number 23, CE 2005-0009, 807 North Flagler Drive.
Good morning. City West Palm Beach Inspector Attilio Belisle. property was initially cited May 1st, 2020 for hurricane shutters installed without proper permit or inspections. The permit was initially applied for, but however, they did not receive the permit or inspections, or receive certified mail and proper posting. City's requesting 30 days to obtain the permit or $50 a day thereafter.
All right, thank you. Let me go ahead and hear from the respondent. Yes, sir.
I'm fine with that.
Let me get your name and
I'm sorry,
address, please.
my name is Mark Rowe. I'm the Director of Facilities for Rosarian Academy.
Thank you, sir.
This came to my attention actually this month because of COVID. We weren't in school session.
Sure.
I did meet with the inspector. He did come back out. We discussed the shutters going up. This was something prior to my employment at Rosarian Academy. I was not aware of it. All our administration has changed since this project originally was started. We're fully willing to either complete or remove the shutters that are in place, whatever it takes to get it resolved.
All right, and the city's recommending an additional 30 days to get that into compliance. So you feel like you'll be able to take care of that in the next month?
I believe so. I don't have any of the drawings or anything, but I believe the city does already have that. We have reached out to the subcontractor that originally did the installation, and we've not got a response back from them yet.
Let me ask Mr. Bilal, do you know if the permit was issued and just was never picked up, or if there were comments that had to be addressed in the application?
Excuse me. The permit was permit number 12060062. It was applied for, but however, never got picked up, and the work commenced without the permit.
Okay.
So it looks to me like without doing some research, that it looks to me that the fees just had to be paid and commence the inspections.
Okay. If that's the case, then there shouldn't be any addition. You should just need to pay for the permit, pick it up, and have the inspections. So I would think 30 days would be plenty of time. All right. Thank you very much, sir. Is there anything else you'd like to tell me?
Nope, that's it.
All right. Anything else from the city?
No, sir.
Okay. Then in this case, I do find proper notice. The respondent is present, and the city has proper documentation in its file. Based on the testimony and the evidence, I do find the property remains in violation as cited, but I will accept the city's recommendation to allow an additional 30 days for compliance. After the 30 days, there will be daily fines of $50 per day until compliance is achieved. Okay. Thank you very much.
Thank you.
Number 22, CE 2005-0008, 4715 Broadway.
Good morning.
Hello.
Whenever you're ready.
Attilio Belisle, City of West Palm Beach Inspector. Property was initially cited May 1st, 2020 for sign installed without proper permit or inspections. We received proper notice via posting on site and through certified mail. Permit number 2006070, the sign was applied for, and permit number 200600072, the electric was applied for but not issued. The contractor apparently applied for the permit, did not receive the permit, installed the sign, but it has not been issued. The city's recommending 90 days or $100 a day after.
Okay. All right, thank you. Let me hear from the respondent. Good morning, sir. If you could tell me your name and address first, and then you can...
Mitchell Shapiro. The business address, or what?
Yeah, that's fine.
4715 Broadway.
I'm sorry, tell me your name.
4715 Broadway.
And I missed your name.
Mitchell Shapiro.
Thank you, Mr. Shapiro. Go ahead.
So we're Boost Mobile dealers, and we hire a sign company to do the whole process from start to finish, permits, installation, inspection, etc. I think our sign guy dropped the ball on this one. He's presently out of the country and just told me this morning that he's going to be returning in December. So at that point, we'll get everything resolved. I think 90 days would be fine because he'll be back in like 60, so that'll give him like 30 days to deal with everything.
So 90 days gives enough time for your contractor to get back in town and get the permits and get the inspections.
I believe so, yes.
Anything else? Yes, sir.
The plan review comments need to be addressed. I noticed some comments that were in the system. If the contractor is able to, it would be wise for him to address these comments so when he gets back in town, he doesn't have a limited amount of time to address these issues. I just want to make sure that he does his part by following through with the plan review comments. Even though he's out of town, he can still do the review.
Is that something that could be done via correspondence?
Yes, it all can be done over the email.
Okay.
Okay.
Probably good advice.
Agreed.
All right, anything else, Mr. Shapiro? Thank you, sir.
Thank you.
In this case, I will find proper notice. Respondent is present. The city has proper documentation in its file. Based on the evidence, we'll find the property remains in violation as cited. I'll accept the city's recommendation, allow an additional 90 days for the property to be brought into compliance. Thereafter, daily fines of $100 per day until compliance is achieved. Thank you very much.
Is that 90 days that clock starts today? Is that how that works?
Yes.
Yeah, you'll get an order that memorializes all that, but the 90-day clock will start ticking
Okay.
today.
Oh,
Thank you.
Number 24, CE 20050019 Linda Lane.
Good morning.
Good morning.
Attilio Belisle, inspector for the city of West Palm Beach. Property was initially cited May 4th of 2020 for a CBS wall that was installed without proper permit or inspections. We received proper notice via certified mail and posting on site. No permits have been obtained. The CVS site wall was built without receiving any required permits or inspections. City's requesting 30 days or $50 a day thereafter.
So in this case, there wasn't even a permit applied for yet?
The permit was applied for, but however, it failed plan review several times for miscellaneous issues. This permit number is a 2012 permit that had never received any kind of inspections, but the work did commence. Permit number 12020074. It's expired, and permit number 05120342 was printed, but however, they had not received any inspections currently on these permits.
Okay. Thank you. Let me hear from the respondent. Yes, sir. If you can tell me your name and address first.
Yes, Your Honor. My name is Gerald Clerk. I live at 344 Linda Lane. I inherited the house from my mother, who, as a matter of fact, passed away in 2013. That's why she didn't respond to the last request after she had applied, and I understand received the permits. There were some issues with the permit. She did not respond because she passed away. I inherited the house after she did. I was totally unaware of the situation. I was in touch. Since I've been made aware of this, I've been in touch with Mr. Belisle and with his colleagues. Since I received this, I've been in touch twice a day, by phone, by email, by numerous people in his department and other departments at permits. From what I understand, well, the inspector came to my house on Monday. From what the inspector told me, he inspected the wall, he approved the construction, and was going to close the permit the same day, this Monday. Okay, so from what I know from the inspector, this is already closed. The inspection has been done and approved. He saw that the issue of damage to neighbors was not legitimate. The height also was conforming to the permits that my mother had received before she passed away. So, I mean, of course, Mr. Belisle will confirm, but as far as I know, the cases or everything has been resolved. I just got an email 5 minutes ago to go to one of the offices here, I assume to make a payment on the permit, which I will do. So, please let me know if there's anything else I can do. I have here all the emails. I mean, it's 2 emails a day plus numerous phone calls every day, even while I was at the hospital a few days back for a heart issue. So I think I've done my part, and I think the case is closed. But again, I will go to the office and see if there's any payment I need to make to finalize this.
Do you happen to know the name of the inspector who came out on Monday and signed off?
Unfortunately, he did not give me a card, and I cannot recall his name. But he was sent by Ken.
Mr. Ken Conrad was the inspector, the chief building inspector that probably instructed one of his deputies to come out and take a look at your property.
So if that is the case, Mr. Bilal, would that just need to be a kind of a paperwork?
Just a matter of paperwork.
All right, then 30 days should be more than enough on this one. Thank you, sir. Is there anything else you'd like to tell me?
No.
All right. Then I will find proper notice in this case. The respondent is present and the city has proper documentation in its file. I'm going to find the property remains in violation as cited, but although it sounds like it's just a matter of having the building folks get with the code enforcement folks and getting everything signed off, which 30 days should be more than enough time, but I will, in an abundance of caution, allow an additional 30 days for compliance. After that, there would be daily fines of $50 per day until compliance is achieved. Okay, thank you very much.
Thank you.
Number 25, CE 20050023, 1221 Andrews Road.
Good morning, sir.
Good morning. Attilio Belisle, inspector for the city of West Palm Beach. Property was initially cited May 4th, 2020. The property was cited for permit number 12030619 and permit number 10120674. We received proper notice via certified mail and proper posting on site. The property has applied for a dust collection system and a ductwork for the dust collection system. However, they've not received any inspections or approved inspections for these permits. The roof over the dust collection system, and I noticed that there was an ice machine and various other items, structures built over the dust collection system. The property will receive 30 days to gain compliance and $50 a day thereafter.
Are there additional permits that need to be applied for as well?
Yes,
That's
sir.
what I'm.
Yes, sir.
That's my-
The additional permits would be for the plumbing, the miscellaneous plumbing for ice machine and
Okay.
things, and the building as well for the lean-to structure that's covering over the. See, there's the ice machine and the dust collection system.
Yeah.
And then that structure that's covering it. If you go to the next picture, I believe you can see an overall view.
Basically, the 2 white columns and then
Then there's this. See the lean-to, the overhang
yes.
structure that they put over it.
Okay. All right, let me hear from the respondent. Good morning, sir. Go ahead and tell me your name and address, please, and then you
Sure.
can.
My name is Amadou Dial. I am a senior project manager for Woolham. Woolham is a general contractor that owns part of this property.
You're the contractor?
Yes, Woolham is a general contractor,
Okay.
but the owner is on the part of this property. The other part is the FPNL property.
Okay, go ahead.
Yeah. So they sent me to represent them because I got this in my desk on October 7th. That was the first time we knew about it, actually. So what
I'm sorry, if maybe get the microphone a little closer. I'm having a real hard time hearing.
As I say, I knew about it about 15 days ago, and I reached out to Mr. Bilal and he explained me what needed to be done.
Okay.
So, yeah, of course, we want to address it, but we want more time because it looks like we may require to hire some design professional to sign off on a drawing. I don't know if the city would accept just a sketch from us. So that's why we require a little bit more time than 30 days to be able to, because I don't control the design professional.
How much additional time do you,
Can we have 90 days?
does the city have any objection to a 90-day time frame on this one?
2 of the permits had already been applied for, so they'd already went through the plan review process for the dust collection system. So those should be pretty much an easy thing. So if we can get those on the 30-day, and then for the structure remaining above, I know they're going to have to get some design professional to design something. I'm willing to go, the 90, but we need to get some inspections on the dust collection system.
Okay,
Okay.
yeah,
You understand what the city's recommending? Do you have,
yeah,
are you in
absolutely.
agreement with that, sir?
Absolutely. So we can call for inspection for the dust collector immediately.
Yes, sir.
Okay.
All right, I don't have any objection to bifurcating the order. Is there a, can we do that by permit number? Because I don't think we can do it by code section.
We can do it by permit number.
Okay, so we'll do it this way then. First, I will find proper notice, respondents, contractors present. City has proper notice in its file. Based on the evidence, I will find the property remains in violation as cited. I'm going to accept the city's recommendation and allow 30 additional days for compliance on the permit that has to do with the dust collection system, which is, I guess, 120-30619. But I will agree to the respondent's request and allow 90 days to comply with the other permit number and getting those violations complied. If either of those deadlines are not met, then daily fines of $50 per day will be assessed until compliance is achieved.
Yes, sir.
Thank you very much.
Thank you.
Number 3, CE 200301442, 1801 Palm Beach Lakes Boulevard.
Good morning, Dan Kempa, City West Palm Beach Inspections. This structure that has been placed at the courtyard at the outlet mall was sited in March of this year, and no permits or inspections have occurred on this, and that's where we're at. No application has been made for a permit either, and the owner was served by mail and posting on the property.
And I see the stop work order references a roof being installed.
Well, a roof or a partial roof. The owner states that it was a, a partial roof, but in any case, it was roofing. And the whole structure, I don't believe, has ever been inspected. I don't know who built it or prefabbed it, but that's where we're at with
I
it.
see at the top, it says placement of prefab structure in courtyard. Are there any photographs on this one?
Yes. They're supposed to be attached. They're not? She just did it this morning. Oh, could it be under 1741 Palm Beach Lakes? Because, yeah, look at that, because there's, over there at the outlet mall, you never know how they're going to address it. 1741? Mm-hmm. Well, hold on a minute. See if we can do it this way. Yeah, I think I may.
Ma'am, what is your name?
Hi, my name is Keely Newman.
Thank you, Ms. Newman. And I'm going to have the inspector show you these pictures. Okay. So the whole thing?
Well, yeah.
Okay. Yeah, go ahead and show. Is there more than picture than just that, or is that the one? Let me go ahead and scroll through them all for me, and then you can take them over and show her. Tilt it. Oh, there you go. Perfect. Okay. Gotcha.
There's the posting and, there's another, another elevation.
Okay.
I think that's it for that one.
Okay.
I think you'll recognize these.
Okay.
And what relief are you requesting?
Let's hear from the owners to see, we're willing to work with her on this,
Okay.
so see what
Let me
she's
go ahead
got
and hear
to say.
from. Yes, ma'am. Go ahead.
Hi. So this structure was not built in West Palm Beach. It was built elsewhere in a different county, and it was brought in by an 18-wheeler truck. I have photographs of that. The only thing that was applied when this gentleman had come there, I happened to be there that day, was just the rain guard around the roof. And I'm happy to share those pictures with you. He did give me personally the ticket, this stop work order, and he and I spoke. My notes say he and I spoke the very next, or 2 days later, 3/9, and my notes say that he told me to call Richard, and I have very little recollection of speaking to Richard, I guess Gathright. So I don't know if I spoke to Richard or Gathright or not, because it says I left him a voicemail at 3:17. He says I did speak to Richard Gathright, but in any event, this was all during COVID. I think at the time, at 3:17, the structure was put in place on 3/6. He came out 3/7. And on 3/17, I never got a response back of what I need to do. And this is an odd situation, because I'm getting a code violation for not pulling a permit for something that was not constructed in the city of West Palm Beach. And so I think the city closed very shortly thereafter, and there was no other communication until 10/16/20, which was, I think, last week. I received a email from the West Palm Beach, my landlord, basically, which is the West Palm Beach Outlet Mall, saying that they had been served in their Boston headquarters. And so there was just no communication from March until just last week. And of course, as soon as I received this, I called this gentleman up, and my goal is to resolve it. It's just a very strange situation that we're in, because I'm unclear of what needs to happen with the structure that was brought in, and they're telling me that I needed to pull permits to build it in the city of West Palm Beach.
Would it make sense to continue this to my next agenda, give you guys a chance to get together and see what needs to be done and see if it can be resolved?
Well, I think that, Kaylee?
Keely.
Keely, needs to go and apply for a permit to place the structure. Once she applies for the permit, she's more than likely going to have to come up with some type of design plans so that somebody can review how the structure was constructed. So once an application is put in for the placement of the structure in the courtyard at the mall, plan review will take a look at it, and then they will correspond with her as to what is deficient as far as design plans, whether it's going to need electrical, plumbing hookups. All that was prefabbed and just delivered there. It doesn't matter if it was prefabbed in another county. It was still prefabbed without any type of design approvals or inspections. So that's where we're at right now. So my suggestion would be to apply for the permit to place the structure in the courtyard and start moving forward, and then
So let me ask you this question, and, I know just enough about this sort of thing to be dangerous. I know that the Florida Building Code does not apply to like a mobile home on interior, but it applies to how it's laid on the slab and how exterior utilities are connected. Is this a similar situation, or does the building
Well,
code
it's-
apply to the whole structure?
It's a little different with a trailer, because a residential trailer, and I'm not sure who the state's put in the hands right now. For a while, it was the Department of Agriculture. Then it went to the Department of Consumer Affairs. I'm not sure who is overseeing that, which department now, but those things come with plaques, trailers, residential
Right.
trailers. They come with a sticker that everything has been looked at and inspected by a third party, and I don't know who they contract to do it, but it comes that way. A structure of this sort is usually done, you have a design specification, and then you have an engineer that seals it, and then an inspection is usually done when it's prefabbed, and then we go out and look at what's called product approvals.
Right.
So you would have all that information, and then we go out and inspect it to make sure it's tied down properly, okay, for windage. Because if a windstorm comes on, it can't just blow away. And that's the way we handle these types of structures, which would basically be the same application as a storage shed in the backyard of a property, right?
So for this to be done in compliance with the codes, all of that would happen in advance of it actually being placed? Or it would be placed and then it would be inspected?
Well, yeah, because before it would be placed, there would be a permit issued. So everything would be in order, and then the only thing that would be looked at after the permit was issued was the placement, and if it was tied down properly, and if there was electrical and plumbing, if the hookups were done correctly, right?
And I believe the photograph showed, at least one of the photographs showed an electrical connection.
Yes.
I thought I saw an electrical cord.
Yes, and I'm not even sure if that's appropriate, because my recollection from March was there was an electrical panel was there not?
Yes, there is.
There is an electrical panel inside of the structure.
Okay.
So that application, that they're taking a rubber cord and coming from an outlet in the garden for the landscape lighting and connecting it to the electrical panel, I don't know how it's connected inside. So the picture that is there, no, it would not be proper in any application, because, ordinances don't allow extension cords to be used as permanent wiring. It's only temporary.
Okay.
So, but now we got a plumbing, if it's plumbed on the inside, all this stuff that was put into the structure prior to closing the walls up, no one knows what's in it. So that's why product approvals would be necessary.
So it sounds like I'm not sure what has to happen first. Do you need to get out, and does there need to be an inspection, or does there need to be an application for the permit to have the prefabricated structure in placed?
Correct. That would be the first step, is to apply for a permit to place the prefab structure in the courtyard at the outlet mall.
All right, and until that process is completed, it can't be used, is that right? Or can it?
I'm not going to say that she has to shut down the operation.
Okay.
I'm just saying that it needs to occur.
Given where we are in city operations right now, what's your best reasonable estimation of the time frame, assuming due diligence and good faith effort by the respondent to get through that process? How long do you think it can be done?
Tyler? Hello?
No, I'm asking.
I know, but I'm going to ask her.
Well, that's what I'm saying,
How
assuming.
long do you think,
Well,
how
because it's
long do you
not,
think you might need if you have to get design professionals to draw drawings, the whole thing? How long do you think it might take?
yeah. So I think that the answer to that depends on what it is exactly that I have to do. I'm still very unclear because I'm hearing, new information just now that now it's a permit to just place something, and I don't even know what that. You and I have never discussed that particular plan, and so I don't even know what that is. We never discussed it, so I can't answer that question. If what he's telling me, what he has communicated to me before is that, well, you really need to start as if you're constructing something here in West Palm Beach, and so you have to go through the whole process, which would be get an architect, get the plans drawn up, do the whole process. If I were building out a space in the mall, for example. And if I had to do that, I would need 120 days. If I don't have to do that, then it could be less. I just am unclear what it is the city's requesting me to do.
Okay.
Does your, obviously your, who you purchased the prefab structure from, they can't provide you with any product approvals, correct?
Well, unfortunately, that person left to go, I guess, to Iowa, where that contractor was from during COVID in March, and never returned to the state of Florida. So I'm kind of just left dealing with that. And I want to add from what he had said before, so the connections, right? So that wouldn't be me. That would be a different entity. That would be the Palm Beach outlets. They are and I'm not sure if they're here or not. The Palm Beach outlet mall, which I lease the space from, that's their cords, and so my lease just says you put it's a kiosk. What I have is a kiosk, and so you put your kiosk there, and then they supply the electrical and the sewer and all of that, and they paid a contractor to come in and to connect to my kiosk. So that's not me.
So let me get some clarification. You're the tenant. You have a lease agreement with the outlets to place your prefab structure.
That's correct.
Out in the walkway.
Yes. And they supply the electrical, which was a
Okay.
predetermined number that then I paid based on that, my lease rent. And what they, and this kind of just opens a can of worms, because there are probably 20 kiosks similar to mine in this outlet mall, and they all connect exactly like mine do.
Can I see the notice of violation? Was the notice of violation, let's see.
You mean the original stop work order?
No, this is for code enforcement, not for the building department. I mean, it looks like the notice of violation was actually sent to Palm. That's why it went to Boston, because it was sent to the outlet. It was sent to the outlet mall, so.
I was never notified. I never received this until yesterday. Somebody, I think, posted
So this
it.
is sort of as the tenant, you are certainly caught in the middle of this, but you're really not the respondent to this code enforcement case. The owners of the outlet mall is the entity that was cited for the violation. You got the stop work order on your structure, but you're not the respondent it seems to me, for the code enforcement case, that the outlet mall is as the property owner. And let me ask the city attorney, is that a correct, do you agree with that interpretation? You're correct. Yeah. So-
I got a call from the outlet mall, and he explained to me, and I haven't read any documents or the lease or anything like that. He's explained to me that even though they're renting her space to put her structure, it's up to her to comply with the codes of the structure that she placed.
And that may very well be the case based on the tenant's arrangement
Right.
with the landlord, but as far as code enforcement is concerned, any order that I issue today goes against the outlet mall. It does not go
Correct,
against the tenant.
correct.
So that's why I said this is kind of a complicated one, because whatever I do today doesn't, if I impose daily fines, they're not against you, they're against
gonna be against the
Palm Beach
outlet.
outlets, but what that does between your relationship with the outlets in your lease agreement, I can't tell you.
What I would suggest is, what do you ask for if you had to go through complete design, 120?
I think 120, so I've never pulled permits in the state of Florida before. You know your process more than I do. I mean, I certainly will move, as fast as I can to do whatever we need to do to resolve it. But I would kind of ask you, knowing your process, if I'm diligent, how long will that take me?
120 days should be sufficient to apply for a permit to place the structure, have a plan review, address any deficiencies. The biggest probably time barrier you're going to have is, I don't know how you're going to provide drawings if you can't provide product approvals or a drawing from the person that built it. So you're probably going to have to go back and start from scratch if that person is no longer available. As we discussed on the phone, and I think in this atmosphere now, 120 days should be ample time.
I have met with an architect. I've found an architect. I have met with him 2 days ago. This is it's 8 by 10 structure. So we're not talking something that is really difficult or challenging. And so I think the architect felt confident after looking at it and being on the inside and outside that it would not be that big of a deal for him to put it down on a blueprint exactly how it's been constructed.
Well, another problem you have is you have interior electrical wiring and plumbing. So that's another issue in the design.
But again, it's extremely simple. Like literally, there's one sink and the plumbing goes straight down, and there are a series of outlets that the eye can see. So he was pretty confident that he would be able to put this on a blueprint.
Well, and the other thing that I'll reiterate something that you said, ma'am, and that you're not the first person to have a kiosk at the outlet mall. Clearly, this exercise has happened with other tenants and with permitting processes through the city, so it can't be insurmountable. I'm inclined to give you all the time that you reasonably need. It doesn't sound like anybody's objecting to the 120 days. Did you say that you got certified mail service for the notice on this
Yes,
case? I just
to
want
the
make
outlet
sure.
malls,
Okay,
to the property owner, yep.
okay. All right, is there anything else you'd like to tell me, ma'am?
The only thing I'd like to share with you is a photograph of the kiosk being delivered on
Sure.
an 18-wheeler. That way, you know that there was no construction going on, or
Sure,
exactly what was constructed. You could look at the before and
Yeah,
after.
let's do the same way we did it. If you want to come up and you can show me and then show the city the same photograph. And what we'll need to do is get both the city's photographs and yours transmitted to the city so that they can be made part of the
Now,
record.
you want to see that first, or?
Yeah, why don't you show that to me real quick, and then, like I said, we'll do it the same way we did the city's pictures. There it is. On a flatbed, okay,
Put the graphics on site.
I see, sure, okay.
It was just the rain guard. You can actually see actually that's it being delivered. So it's just the rain guard that went around the first row. The roof is on.
I see roof trusses.
Yeah, because they went right into there for the rain guard. They applied with 1 foot, I don't know what that's called, just a thing that hangs over 1 foot all around the front. That had already been.
Like a little
pre-constructed.
soffit or whatever.
They applied stuff because the Department of Transportation only allows 8 feet going down the highway, so we couldn't have that on a vehicle going down the highway. So it had to be applied on site to be compliant with the DOT rules.
Sure. Okay, I am going to make both the respondent's photograph and the city's 3 photographs part of the record, so they do need to be transmitted to the code enforcement department so they can make them part of the file. And I'll let
My
you guys figure
photographs?
out how to do that offline.
Okay.
You just need to email the picture to the city. But I am going to find proper notice with the certified mail in this case. I'll grant the 120 days to comply with this and get through the process. I do find the property is in violation as cited. Even though you're not the respondent technically, I mean, clearly you're inextricably intertwined as the tenant. If you, my suggestion would be if you're getting like past the 90-day mark and it doesn't look like you're going to be done, speak to the city, speak to the outlet folks. I would be, assuming good faith progress and unforeseen circumstances, I will be happy to listen to a request to extend that time frame as long as that happens before it runs out. And then this will, I'll do $100 a day fine if the time frame is not complied with one way or the other.
I'm sorry, could you repeat that?
Yeah, after the 120 days, assuming there are no extensions, there'll be a daily fine of $100 per day against the respondent until there's compliance. Again, I'm happy to listen to a request to extend that time frame if need be so that those fines do not start to run.
Okay.
All right? All right, thank you very much.
Number 4, CE 20030146331 331 South Sequoia Drive. Number 331 South Sequoia.
Excuse me?
We called number 4, 331 South Sequoia.
Dan Kempa, this property was cited, is there anyone here for 331? I guess not. This property was cited on 3/7 of this year, 320, and what it is a complete interior demo and tear out basically of the interior of the home. I spoke with the owner. He was going to go down and get a demo permit. COVID came. Never have heard anything back from him. I did have photos, but apparently they didn't get loaded as the same as the previous case. And I went by the property and it's still in the same state it was 2 months ago or 3 months ago when the dumpster was observed full of all the interior tear out, and nothing has happened on the property, and no attempt has been made to apply for any type of permits. Oh, there it is. No, wait. Yeah, you got it. And the other ones weren't there? Wow. And this is where we stand with it. So the city would suggest 30 days to comply or $100 a day thereafter to get permits.
I say by comply, you mean obtain the necessary permits.
Correct.
Is there anybody here on behalf of the respondent for this case? Does not appear that there is. You did have proper service with certified mail, I saw though, so I will find proper notice. Based on the testimony and the evidence, I do find the property remains in violation as cited. I will accept the city's recommendation, allow an additional 30 days for compliance by obtaining the necessary permits to complete the work that was started without the permit. And thereafter, daily fines of $100 per day will be assessed until compliance is achieved.
Thank you.
Thank you.
Number 2, CE 20080256, 600 Westwood Road.
I thought that one was specially set for 1 o'clock.
They'll explain.
We moving that up?
No, we're rescheduling. She's protesting that we're rescheduling. There was definitely miscommunication. The notice that was computer generated said 9 o'clock was not changed to 1 o'clock. All the complainants, which is many, are coming at 1 o'clock. So we either need to reschedule, or if the magistrate wants to give us a continuance to 1 o'clock today, we'll take that.
Magistrate Davis, my notice is 9 o'clock in the morning. I am here. I spent Saturday night, I spent Sunday, I spent Monday, I spent most of yesterday until 9 o'clock last night preparing. I am here. It's on there. Arlene has agreed. This is the notice that was sent to me. It's on the docket for this morning. I saw it. I signed in. I'm respectfully requesting you just dismiss this case, and they just have to do a new violation. I'm here.
Linda,
Let me ask.
can you put your name on the record and how you represent the
Oh, I'm sorry.
the
Linda
respondent?
Weitzman for Kurt McDonald, one of the owners of 600 Westwood Road.
Sir, I'd also like to add that this was originally scheduled for a previous date and was continued from that date at her request.
Okay, so question, normally when things get specially set like this, it's because they're going to take an unusually lengthy amount of time. Is that the case with this case?
That is the case, sir.
But, Your Honor, he's paying me to be here today, and my
Just a
notice...
minute, ma'am.
I'm sorry.
I'll come back to you, I promise.
I'm sorry.
Because, you know, the agenda that I was provided yesterday and the one from this morning does say that this hearing is set at 1 o'clock.
Would you like to see my notice?
I've got 67 cases on the 9 o'clock agenda, and I've got another 6 on the 11:30 agenda. If this is going to take an hour or more, I'm not interrupting the morning agenda for that. It appears it was, if there was a scrivener's error in the notice,
We can see there was an error in the notice that was generated. We did not
and
correct
you
the time.
can't come back at 1 o'clock, I'm happy to reset this for another day, but I'm not going to take up the entire morning for those, and
But Magistrate Davis, you know, in all due respect, my notice is right here. My notice is correct. My client has to pay for me to come down here and prepare. And because it's their fault, they should be required to renotice. I don't have a special set notice. They agree that this is, he just conceded, this is the notice that I was given. I'm here. Okay, it's not my fault that they didn't renotice it and give me a copy of it. Okay, it's just not,
I'm not blaming you for anything, ma'am.
No, I understand, but my client is he's paying me to be here.
Understood.
And it's their fault, they admit it.
Understood. So now here we are at a hearing that I am presiding over, and what I'm telling everybody is if this is going to be a lengthy hearing, I'm not going to take up the other 67 plus 7 cases for your one hearing that on my agenda says 1 o'clock. So I'm going to give you a choice. You can either come back at 1 o'clock or we can reschedule this. Those are the two choices. I'm not going to take up my entire morning for one case when I have that many others.
I didn't ask you to do that. I'm just asking you to dismiss the case because it was improperly noticed. And I hear in all these other cases, you're checking the notice as a duly noticed. So you have a copy of something I don't have a copy of. And I understand, I respect you don't want to spend an hour and a half. I agree. But they should have sent me a notice that was correct. You're the only one who has it, not me.
And again, I'm not blaming you for anything. I'm simply telling you that you can blame me. I'm not willing to hear this case this morning during my regular agenda. I will hear it at 1 o'clock, or we can reschedule it. I'm happy to do either.
It wouldn't take...
Those are the two choices.
I understand, but without his witnesses, it wouldn't take very long.
Well, the other choice is to get through the rest of the agenda. I mean, how long is this going to, how long is it, like, as I said originally, usually when these kind of things happen, it's because it's going to be a lengthy hearing. And I'm happy to give you all the time you need, but not at the expense of the 67 plus 7 other cases that I have this morning.
I think no more than 20 minutes.
I think between 1 or 2 hours.
No, I mean, for today, for me to present this case now, be 20 minutes, max. Well, can't say max.
Do we have other respondents present for the 9 o'clock agenda? Have we gone through? We have a couple more.
We have
2 or
2
3.
more.
Thank you,
3.
sir.
We do have some, but the other respondents for the Westwood case are not here because they were planning on coming at 1.
Let me hear from the city attorney. What is the city's position on this?
We do have all our other code enforcement officers waiting.
Sorry, I'm having a hard time.
Oh, I'm sorry. Can you hear me now?
A little better.
We do have all our other code enforcement officers waiting to present their cases as scheduled. We don't have a problem rescheduling based on everything that, has come out. I don't think that it'll take, less than an hour.
So your estimation is at least an hour?
Yeah.
Okay. In my experience, normally when it's at least an hour, it's usually 2.5.
But we can reschedule for,
Well, again, I'm happy to come back at 1 o'clock, or I'm happy to reschedule. Why don't you guys talk offline which way you want to do it? But I'm going to stick to that position. I'm more than happy to do either. Why don't, if you two can speak offline, and we'll continue our agenda, and let me know what you want to do.
Well, is it possible that the city be fined for my services for being here this morning?
I beg your pardon?
Is it possible for the city to be fined for my
No.
being here for proper notice?
I'm aware of no basis in the law for that at all.
Okay.
Okay, if you can just take a few minutes, see what you guys prefer to do, and let's go ahead and proceed with the next case on the regular agenda.
Number 16, CE 20080199, 1500 North Congress Avenue, Unit A17.
Do we have Mr. McFarland?
I believe this case got transferred to another officer that I've been dealing with is a Marcus Williams, if that helps anybody.
Okay.
That's what I've been dealing with on it.
Thank you.
Good morning, City of West Palm
Morning.
Beach Code Compliance Officer Paul McFarland. On August 17th, I received a complaint from the tenant of 1500 North Congress, Unit A17. The property was cited for repair of interior walls, equipment maintenance, AC in need of repairs, clean and sanitary, carpets in bedrooms saturated with water, rental license violation, and certificate of use. The property was posted October 1st, 2020. Certified mail was sent, property was posted October 1st. Certified mail was sent August 18th. Certified mail was returned August 22nd. I have been in no contact with any representatives of the property.
You said no contact, or you did have contact?
I have no contact.
No contact, okay.
I've only been dealing with the tenant. I spoke to her Monday morning, and she advised that the AC was repaired, but the saturated carpets have not been replaced, and the certificate of use has not been applied for, or the rental license. With that being said, city is recommending 30 days to come into compliance, or $200 a day until compliance is achieved.
And I'm sorry, I'm sorry I'm having a hard time. What was your recommendation?
30 days or $200 a day until compliance is achieved.
Okay. Let me hear from the respondent. Yes, sir.
Hi, I'm Terry McManus. I'm the owner and founder of Rent Finders USA. I'm the property manager for the owner, who is a retired New York police officer, lives in New York City. I've had the property for a while. Just first want to address, he said no communication with representative from the property. When I called in the number I received the notice from the owner's lawyer in New York. They got noticed. I called in on the number on here to speak to Mr. McFarland, and I was directed to a Marcus Williams to handle the case. That's who I've been dealing with at 822-1472. So that's for starters as to why there's been no communication with us, because I was directed to somebody else from the city. Second thing is, this property was renovated right prior before the tenant moved in. She inspected the property. Everything was hunky-dory. Subsequently to that, there came this mysterious leak through the closet, which is what I believe the whole nature of this, other than the rental license, which that's actually on me, it fell through the cracks, but I have evidence, I've applied for it. But as far as that water leak, because the closet's a small, 900 square foot apartment over by the outlet malls, the closet was right next to the air conditioning unit, and it is typical that those air conditioning units the drain may clog, the pan may fill with water, and they would leak. That's where we assumed the water was coming from. So we sent the AC guy out. He did an overhaul to the AC unit, and we removed the carpet so that we could see where the water wouldn't come back. The water never come back, so we figured it was resolved. Subsequent to that, we found out the water leak came back, sent the AC guy out. There was nothing wrong with the AC, brought the condo association manager maintenance in there, and they discovered that the water was actually leaking from the adjoining condominium unit, not from this unit. They went in there, did whatever they did, and subsequently we've never had any water leakage since then. I also have the receipt from the carpet cleaning company, and this goes back to, I was looking for a date here, but it was like in June that the carpet had been cleaned subsequent to that. So this all goes back to June, and I don't know when he said he got the complaint from the tenant. And also, I just want to ask, has he ever physically been to the unit? And physically seen it yourself inside?
Well, so that I understand, your testimony is that the issues were resolved in June. All of it was resolved in June?
In June, except for the leak that the association resolved, and it was coming from the unit next door, and the occupational, the tax license that
Okay.
I have the email that I applied for on the 9th, and I have all the application here, but there's a little process with COVID, as you can't just
Sure.
run down and do it.
When did the condo association do their piece of this?
It's been a little bit of an ongoing event since, I'm going to say, August.
Can I see the notice of violation, please?
And if I could help just kind of smooth things along, he said he allowed 30 days. An additional 30 days, I think we could produce the photographic evidence. By that time, the business license would be issued. I have no problem just moving along and say, give us 30 days. We'll make sure everything's, certainly complied with.
There you go. And, more. Let me see the next page, please. So the question would be, if the carpet and those interior issues were completed before September 28th,
Well, let me
and
give you,
you reached out to the city at the other number, I'm reluctant to, if that is truly the case, then there's a question of whether or not that would even be in violation, because,
I don't think we're in violation. I think we've completely complied, but I'm just saying if they want me to get more evidence for them in 30, over the next 30, I'm happy to do that. You know, my office is up the street here. We're friends. But I just want to say the photo that they showed of the carpet, that photograph had to be from, first of all, it had to have come from the tenant. You see the people in the tenant, but because I personally removed that piece of carpet from the closet and threw it in the dumpster in September. In August. Personally took the carpet out, threw it in the dumpster. That section, it's this wide and this big. It's bare concrete right now because I didn't want to put new carpet in till we ultimately finally resolved the issue of the leak coming from the other unit. But it's a very small piece, so for them to even show a piece of carpet on there, I don't know where that picture came from. It certainly was way long ago, probably when the tenant first complained to me that, hey, we got a leak here, and I sent multiple people out, carpet cleaners out, cleaned the carpet, and then subsequently removed that, 2-foot piece.
okay, and the name and telephone number of the person that you were instructed to
Yeah, sure.
correspond with is?
This is who I've been corresponding with. I asked for him this morning when I went up there, is Officer Marcus Williams, phone number 822-1472. Email is majwilliams@wpb.org.
After the condo association did its piece of this, did you reach out to Mr. Williams?
Yeah.
And if so, was that before September 28th?
No, Mr. Williams has been, within the last 30 days, I've been corresponding with him. And he said it's his case. I mean, I had clear communication with him.
Let me come back.
Your Honor, the confusion is,
Yeah.
Mr. Williams was out of the office due to COVID, and I took this case. So I think that's where the confusion came from. But if anyone did their due diligence, they would have seen I was tied to this case.
Yeah, well, like I said, on the notice I got, it clearly says Mr. Paul McFarland has his phone number. But when I called city to reach him, they said this case is handed over to Marcus Williams, gave me his number. Otherwise, it's handwritten. I wouldn't have had any way to reach that guy or get his number. So that's how I went and tried to reach him. And, ultimately get this resolved before we got here today. And his issue was, as long as you have the real issue was over that was lingering was over the business tax license. He said, as long as you've got that applied for prior to coming in, we'll get it. So I applied for it here on October, I can't see if it says the 8th or 9th. Did exactly what they asked to mail in it with the documents, the application completed, as well as the deed to the property, which, I just did it because it said supply the deed. So I have a copy of everything and a copy of the email where I sent it to the city, business tax at WPB.org.
Yeah, I mean, it does sound like the rental license and certificate of use is still an outstanding issue, so I think there is a violation there.
I'm saying, you saying it is a violation?
Yeah, I think if that hasn't been complied.
Well,
Yes, if it hasn't been issued
Oh,
to you in
understood.
hand,
Yeah.
it's still a violation.
Understood. I mean, I've done everything I can to have it issued.
If you can provide proof of the other outstanding violations, I'll comply it.
So let me give you this one also, because there's the issue of this broken door. We put a brand-new door in the place before the tenant.
Tenant has testified to me that the door has been repaired.
Right. Well,
That's not a question.
Let me just state this, because this tenant is a nuisance, for starters. But I put a brand-new door on that bedroom before they moved in, and her children broke it. Because I got the violation, and I'm not here to fight, I spent the money. She should have paid for it. I spent the money and put in another brand-new door. I also, prior to her moving in, had personally put in, because I didn't have a maintenance guy available, and she was moving the next day, a brand-new food disposal in the kitchen a week after moving in, she said the food disposal doesn't work. I said, okay, we go over there because it's possible it was defective. Go over there. I'm pulling bottle taps, plastic, beer, ties, everything out of the food disposal, laying it on the counter. I said, you can't put this stuff down to disposal. And she calls me like I'm hotel maintenance to come over and fix it. So,
Did you say that you had copies of emails regarding the carpet and the water heater issue to the city?
no, the only copy of the only email I sent to the city was regarding the business tax license. That's how they ask you to send in the application in their days of COVID. Right now, you can't really apply in person, and it says better do it online.
All right, thank you, sir. Is there anything else you'd like to tell me in this case?
Oh, no, sir.
Mr. McFarland?
No, no, Your Honor.
All right.
If I could just ask Mr. McFarland, if there is an ongoing issue here, whether, is this the correct, first of all, is he the guy on this case now, which it seems that he is, and I apologize, and he can be reached at 822-1478?
Correct.
Okay. I'm happily giving my cell phone number also if he wants to be able to reach me directly.
All right, so I'm sure nobody's going to be happy with this result, but that usually means I'm probably in the right place. I am going to find proper notice for this case with the certified mail, the posting, and Mr. McManus being present. I'm going to find the property to be in violation of 18162A and 2232A regarding the rental license and certificate of use. I'll allow the additional 30 days to comply on that. I'm going to reserve ruling on the other violations regarding the interior, the AC and the carpet. And Mr. McFarland, I think you said that the tenant did indicate that the
AC
door
was
had been
repaired,
fixed.
but she was still complaining of the carpet.
Pardon me?
She did state that the AC was repaired, but she was still complaining about the carpet.
Okay, well, I'm going to find the 18103C regarding the broken door was complied. I'm going to reserve ruling on the AC and the carpet because it sounds like there may have been some miscommunication, and it's, you know, I have the sense that the respondent did act in good faith to try and get that one resolved before the end of September, which was the date in the notice of violation. I'd like the city to inspect the property if you feel like you have sufficient evidence to bring back a case for, assuming it's in compliance, for a finding of fact. Feel free to do so. If not, then I don't know if I'd have to do something further on those, or if they would just there would be no finding of violation in that case. But I'm not going to make a finding on those today based on what I've heard. So 18103C is complied, 18162A and 2232A are remain in violation with the 30 days. I will assess a $100 a day fine if they're not complied within the 30 days. And then I'll reserve ruling on 18103I and 18106A pending further action on the city. You can either bring those back or you can dismiss them
And the
out.
one that you're speaking that's in violation is still regarding the tax license.
That's all.
Right, so I mean, nothing further I can really do except wait to hear from them that we've applied,
Right.
but I'll follow up, make sure they have it.
Follow up with that.
Yeah.
I've found
Yeah,
you in compliance on the door, and I'm reserving ruling on the AC and the carpet, because it sounds like that may have complied in time, but
Yeah,
I'm
and I'll
giving
speak
you
with
an
Mr.
opportunity
McFarland
to-
outside. We'll get on the same page. It'll be easily resolved.
Okay,
Thank you.
thank you.
Thank you.
Hopefully you can figure that order out.
Number 61, CE 200801112, 2030 East Parkway.
Did you say 61?
Yes.
Okay.
Good morning. Cassandra St. Hilaire, Code Enforcement with the City of West Palm Beach. This property was cited on August 11th. Certified mail was signed for on August 15th. The property and City Hall were posted August 12th and October 13th. I've had no contact with the property owner. The property was cited for 94-442C1 and 94-451A. At this time, the city is recommending an additional 60 days or $150 a day until compliance is achieved.
Okay, so that's the artificial
The artificial
in the
turf,
front
yes.
yard? Okay. All right, let me hear from the respondent. Yes, sir.
Yes.
Let me get your name and address, please.
My name is Kenny Evelyn. The address is 2030 East Parkway.
I'm going to tell you, I'm having a real hard time
Me too.
hearing you, but do your best to speak, I guess, a little bit more slowly.
Do I
And
have a standalone microphone that I can use?
well, I think if you just get right up on that one, that might help.
Kenny Evelyn.
That's a little better.
That's better? 2030 East Parkway.
All right, go ahead.
All right. I thought this was resolved over 2 years ago when I went through 5 months of meeting with the mayor, being in one of these hearings with the commissioner.
I can't understand anything you're saying through that mask. I don't know.
Is it possible for me to use that mic?
I don't know if that'll help. I think you've got a really cranking mask.
I'll take the mask off if I can back up from this area. So if I can use that mic.
That might help. I don't know.
Can I ask the question?
Pardon me?
He wants to use that microphone.
You can give it a try. I think the mask might be the issue.
Is it on? Okay.
Yeah.
The mask is an issue, but I'm at high risk for COVID, and I've been watching people come up here, take their mask
Oh, no,
off,
I
speak in this little box, so I'm not in a
completely,
rush to
sir.
go up there and do that.
Understand completely.
So my name is Kenny Evelyn.
Yes, sir.
The address is 2030 East Parkway.
Go
And I
ahead.
really wish that y'all still offered video for people at risk. It would have been a lot easier for me and a lot less worrisome for me to come in here and do this. But I heard I missed that by one hearing.
Well, here we are, so go ahead.
So I thought this was resolved 2 years ago. I went through 5 months of dealing with this, meeting with the previous administration, with the mayor, with the commissioners, all the different departments. I went to a hearing just like this. I spoke about this in detail. I brought a petition. I went through everything I could think of that I don't even know where to start with this. So at the end, I spoke with Angela Jones-Van. The last thing that I was told over 2 years ago was that I'm no longer going to be pursued about this, and they're going to have a meeting about artificial grass. Maybe it'll change. Who knows? And I get this notice however many months ago, and I call them up. They say they have no record of it. I call back to Angela Jones-Van, and she said, yes, she did tell me that, but she didn't mean forever, that they had a meeting and the code didn't change and I'm still in violation. So here I am back again, fighting the same fight I fought for over 5 months, over 2 years ago, thinking it was over.
Magistrate, may I speak?
Yes, sir.
Okay. This was heard a little over 2 years ago. It was actually decided over 2 years ago that he needed to resolve it or would be fined. And subsequently, they showed up at a commissioner meeting, and the mayor at the time tabled it to review the code. They did make a change to the code. The change was that in the side setbacks, you can have turf. Nothing was changed in the front. Bottom line is he was never told he could keep it. I've spoken with Angela Jones-Van. I've spoken with all the people involved 2 years ago. Nobody has told this gentleman that he can keep this. The old case was closed because it had been so old. He was recited. And the bottom line is he still made the change of installing artificial turf without getting a permit or asking anybody, hey, is this even permissible? So it was still his own doing.
Can I respond to that?
Yes, sir.
Okay, that is not true. This all started, I was hoping not to go through this whole story, but it seems like it's necessary. 5 years ago, the Coleman Park project, I was a part of it. There's 4 houses right in front of Coleman Park. The city put it in, I applied for it, I got it, very thankful. All the 4 residents was at the last hearing 2 years ago to complain about what I've been complaining about, and everybody's been complaining about to the Housing and Development Department, was about the grass. The material from the previous houses that was there was mixed all in the dirt. The grass, no matter how, all 4 of us spent years watering that grass trying to get it to grow properly. It wouldn't. So I spent 3 years saving money to take care of the front and the back of the property. I hired a contractor because I wanted to put in a driveway. I was rejected 3 times by the city because they said I didn't have enough space for any more concrete. My property had to hold a certain amount of water, so whatever. So fast forward past that, I finally just got the back concreted. I went in to find, since I saved up this money to take care of this stuff, I went to find different options for the front. I went to the city, right in this building, right under there, and I told them, I said, listen, the young lady that was there, I said, I've been rejected 3 times. I'm thinking about putting in artificial grass. Is there any problem with that? And she said, and she at first didn't know what I was talking about. I was like, it's artificial turf, and it's not permanent, because she asked, is it permanent? She was asking me different questions. I said, no, it's not permanent. You put a sub base on, you put it on top, and that's it. And she said, well, it shouldn't be any problem if it's not permanent. That was the start of the problem. Because if I was not given that wrong information, or like Angela told, if I was told to go upstairs, we would not even be here. I would not have to have gotten on the news. I have to go walking around all my neighbors signing petitions. All of this would have been avoided, and I would have had that money in my pocket, the money that I've saved. So after all of that, I get the price of it, which was ridiculous. It's like $12,000 installed. I do the work myself over 3 months after work and on the weekends. My neighbors watched me. They thought I was going to die some of those days. It was very hot days. Finally get it all done, and not less than a week after getting it done, I get a notice saying that I'm in violation. That's how all of this started. Now, since then...
May I interrupt you and ask a question? Did the city issue a permit to install the artificial turf?
No. I asked her, do I need a permit? That was part of the reason why I went up there, because I've been rejected so many times. I wanted to make sure that especially with the amount of money that I was quoted on how much this thing costs, that it was allowed. And I was giving bad information. Now, I'm not an advocate for artificial grass. Honestly, I don't care about it. What I do care about is my hard-earned money that I saved up to do this, and was given bad information. It's not like I just did this and said, I don't care what the city thinks. I went and purposely asked and was given bad information. Okay, and I spent all this time and money on this situation. Now the city tried multiple ways over that 5 months to try to work with me. They tried to see if there was any money left with the Housing and Development Department to help me move the grass and replace the grass there. Nothing came of that. They said, oh, we don't have any funds available. Like I said, it was a long 5-month process until we got to the point where I called Angela Jones-Van, and she told me that I would not be pursued about it anymore. And she did confirm that she said that, because after you said there was no record of it, I called her and she said, yes, I did say that, but I didn't mean forever. They had a meeting and you're still in violation. That's what was told to me. So no, there might not be any written record or anything, but she did acknowledge that she told me that.
So, and I was going to interrupt and ask another question, but you just answered it. So you don't have any documents or letters or anything in writing from the city about what you were told?
Her and she had her coworker, I forgot his name, I spoke with him before. They were both on the phone, and they both acknowledged that she acknowledged that she told me that I'm not being pursued about this anymore 2 years ago. Then she also acknowledged when I called recently after the fine that she didn't mean forever. That's exactly what she said. She said, I didn't mean forever. They had a hearing and they were found you were still in violation, so you have to go to this hearing again, and which is why I'm here. And this is the most frustrating part about this. Not only did I think it was over, but at this point, I've lost my job. I'm currently disabled because I was injured on my job, and now I'm being faced during a pandemic with being charged $1,000 a day for something I was given misinformation about.
All right, well, I don't think anybody's looking to assess you $1,000 a day for anything.
And we're certainly
Just
willing
going by
to
what
give
the
any
fine
amount
said.
of time that might be needed.
Mr. Posner, I'm sorry, I didn't hear you.
We're certainly willing to give any amount of time to get this done. I'm certainly sorry he's injured and unemployed. But the violation is still there. He was never told that he was going to keep it forever. His version versus what Angela Jones Van told me don't exactly mesh. This is the first time I'm hearing that he attempted to get a permit the first time around. He doesn't know who he spoke to then. I don't know who he spoke to then, but anyone of authority knows that changing the landscape needs a permit, period, whether it's artificial turf or not.
Well,
Sir, he's saying it's the first time he's heard of it, but it's on video in the last hearing with me giving testimony, just like I am now, about everything I'm saying. I brought videos, I submitted samples, 5 months of this was done. So maybe he's never heard of it because he didn't do the research, but this has all been said before.
I mean, I've got the city code up in front of me right now. It's very clear that artificial turf under 94-451A 4 is only allowed on residential lots in the rear setback and the side setback. Clearly, by looking at these photographs, it is in places other than that. So there's no question in my mind that it is in violation of that city code section.
Can I ask a question about that I keep asking even 2 years ago, that I asked the mayor and everybody else? Why exactly is it a ordinance violation in the front only and not in the sides or anywhere else?
That does
What
above
is the reasoning behind that
You
ordinance?
would have to ask your elected officials that question. They are the policymakers. That is
Again, I asked him in the last hearing with everybody present. Nobody could answer it.
I did not make that rule. I'm simply here to preside over the hearing that alleges a violation of that rule. Why that is the code in the city of West Palm Beach is an answer that can only be given by the elected officials who make policy. So I see the city attorney coming up to the podium. Yes, ma'am.
In 2012, we had an ordinance that artificial turf was not allowed anywhere in residential. That changed in 2018 to allow side and rear, but it did not allow front.
Okay.
Well, the question is, do you know why though? Why it changed for everywhere else
Well,
but the front?
and again, why is irrelevant to me in this proceeding. It doesn't matter why. That's the fact of the matter is it is a violation of city code at this time. Or is there anything else you'd like to tell me, sir? Anything else from the city?
No, sir, just that all we can do is enforce the existing code. We don't know why they make the codes they make.
If anything is in doubt, I'm pretty sure that Angela Jones Van is not gonna disagree with what I just said. I represented everything that she said exactly how she said it. So.
Well, and even I have no reason to believe that what you're telling me is inaccurate, but under the law, neither a city staff member, nor an elected official, nor me, nor anyone else has the authority to override adopted city code. If you feel you were told something and you relied on that to your detriment, you may have other avenues that you can pursue. I'm not here to give you legal advice, but in terms of this code enforcement hearing, the city does have proper notice, respondent is present, and the evidence is very clear that the property is in violation as cited, so I do make that finding.
Magistrate?
Now, the city's recommended 60 days to comply. I'm willing to give you more time if you need it.
So I'm currently on a forbearance. I can't even afford to pay my mortgage right now. So you could give me 60 days. Hopefully I find a job by then. But I mean, all I'm hearing right now is that y'all are going to find me out of my house right now, because I have no idea how I'm going to pay for this. And again, this is not something that I purposely created. I would think that the city would have some leeway in how they deal with certain situations. And I can't believe that 6 months is the best that you can do after all that I've been through with this situation.
All right. I understand the city's recommendation, but I'm going to give you 120 days to comply, which is basically 4 months. And if compliance is not achieved in that period of time, I will impose a $25 a day fine, which is significantly less than the city is recommending in this case, but I think that is the appropriate remedy, and I will sign that order.
Magistrate, before a final ruling, can we request that you make it 6 months instead of 4?
I beg your pardon?
Can we request you make it 6 months instead of 4?
I have no objection to making it 180 days. Go ahead and make it 180 days.
I was trying to get in there.
Do y'all have grants that's available maybe that'll be able to help me move? Like I said, I don't care if you want to, if the grass can't be there, that's fine. But I feel that I'm in this situation due to bad information. I feel like the city should help me fix this situation. It's not like I didn't go in and seek the information and make sure I wasn't wasting my time and my money.
And there may be, I don't know.
I don't know of any grants as far as landscape is concerned.
sorry.
I don't know of any grants as far as landscaping is
I don't
concerned or
know.
anything like that.
I don't know.
After hearings, I can ask and, oh,
I mean, I don't know of anything. We can refer him to Housing and Community Development and see if there's anything through that. Or county might have something. So we'll talk offline.
So you may, why don't you speak with the city staff offline outside of the hearing? There may be some suggestions there. All right, thank you very much.
Have a good day. Do we have any other respondents present? Do we have any other respondents present?
Where are we going?
No? Okay.
just for 11:30.
Oh, where did, before you call the next case, where did we land on that
600
agenda item number
Westwood.
2? What did you guys decide?
It'll be rescheduled.
Rescheduled, okay.
Okay. Okay.
Hey, give that one to Kevin. Kidding.
Number 1, CE 20090349, 1517 6th Street has complied. Number 2, CE 20080256, 600 Westwood Road is rescheduled. Number 5, CE 20080285, 411 Forest Hill Boulevard.
Good morning, Officer Lester, West Palm Code.
Good morning.
This property was posted on 10/6/2020. Cert mail was not returned. The property was posted for roof walls and foundation repair, exterior painting, excessive growth, landscape maintenance, rental license, certificate of use, debris and overgrowth, fence permit, fence repair, landscape areas must be grassed, some areas. Landscape of swell and parkway must be sod, and landscape maintenance all overall. Unpaved parking and removal of prohibited commercial vehicle. The only 2 that's in full compliance is the rental license and certificate of use.
Those did comply or don't?
Only 2. Rental license and certificate of use is in compliance. It was a renewal, and he paid his fine fees.
So all the other ones are still in violation?
All others are still in violation. I'm asking for, which I spoke with the property owner, he needs an additional 30 days or $100 per day after.
What was the work they did without a permit on the fence? Was there, that brown fence right there?
We can really exclude that one because he needed to repair a fence that was already installed with the
Okay.
permit, so.
Okay. Okay, I will find proper notice with the certified mail and the posting. We are all out of respondents. No other respondents are joining us this morning. Is that correct? Okay. I will find proper notice with the certified mail and posting. Based on the testimony and the evidence and photographs, I'll find that the property has complied with 18162A and 2232A, but remains in violation of all the other sections that were cited in the notice. I'll accept the city's recommendation, allow an additional 30 days to comply, and thereafter daily fines of $100 per day until compliance is achieved.
Thank you.
Number 6, CE 2009040, 6108 South Dixie Highway, Unit 4.
Officer Luster, West Palm Code. This property was posted on 10/6/2020. This is a restaurant. He cited for certificate of use, business tax receipt, and engaging in business without a license. I have spoke to this owner, emailed this owner the application more than once. He's returned the application twice, not filled out properly. I spoke to the actual tenant at the location and instructed him the reason for needing the license, because it is his license, and I've gotten no results. So I'm asking for $100 per day on the certificate of use. I'm asking for $100 per day on engaging in a business, and I'm asking for the $250 fine for the business tax. And 30 days if not compliant.
All right. You had posting and certified on this?
Certified was not returned, and posting was on 10/6/2020.
Okay, then you have proper notice. Based on the evidence and testimony, I will find the property remains in violation as cited. I will assess a one-time $250 fine for the violation of 82-144, the business tax. I will allow 30 days to comply with the certificate of use and engaging in a business without the proper licensing. And thereafter, daily fines of $100 per day until compliance is achieved on those.
Thank you.
Number 7, CE 20090252942 Ardmore Road.
Don Williams, Code Enforcement, 942 Ardmore Road was cited for 94487-B-5, screening of a restricted vehicle, and 26-35, which is a repeat violation. I cited the property September 18th, 2020, posted the property September 29th, 2020. No contact with the owners of the property. I'm going to be just asking for a finding of fact. The only remaining violation, actually, I'm withdrawing the repeat violation because the previous case was not adjudicated before a special magistrate. So only the violation is the screening of the vehicle, which is 94487-B-5.
That's
and I'll be asking just for a finding of fact.
That was the thing in the driveway.
Yeah, the boat or the camper.
Oh, I see. There's a boat too.
He kind of switches them out.
Okay.
One to the other.
What relief are you seeking?
Just a finding of fact today.
Finding a fact?
Yes, sir.
Okay. When did the notice? What was the timing on the compliance?
Signing the property September 18th, posted it September 29th.
What was the compliance deadline?
I'm sorry. The compliance deadline was September 30th.
And they complied when?
After the 30th of September.
Okay. All right, I will find proper notice. In this case, I will find the property is now in compliance, but did not comply within the time specified in the notice of violation. Issue a finding of fact only. Thank you.
Thank you.
And that is for just 94487B5.
Yes.
Thank you.
Number 8, CE 200903340, 604 Claremore Drive is rescheduled. Number 9, CE 200902429 1916 Mercer Avenue.
Morning. Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 1916 Mercer Avenue was cited on 9/17/20. Certified mail was sent on 9/22/20. Certified mail was returned. The property, as well as City Hall, was posted on 9/21/20. Property was cited for 18162 rental license, 22-32-A certificate of use, 74-34-A-1-J garbage can placement, and 94-482-A parking requirements, and 94-71-C. As of last evening, I noted that all violations still remain. There has been some attempt to make some corrections. That said, though, all violations still remain. The city's requesting 30 days in order to comply, or a fine of $100 per day be imposed.
All right, thank you. I will find proper notice with the certified mail and the posting. I will find, based on the evidence, that the property remains in violation as cited, and accept the city's recommendation, allow an additional 30 days to comply. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Number 10, CE 2009-0275, 2727 Hillsborough Road.
Morning, Michael Williams, Code Enforcement Officer, City of West Palm Beach. Property 2727 Hillsborough Road was cited on 9/21/20. Certified mail was sent on 9/22/20. We do have a signed certified mail receipt on file. The property, as well as City Hall, was posted on 9/21/20. Property was cited for 78-1, obstruction of the public right-of-way. More specifically, blocking of the sidewalk with a staged dumpster, and 94-6, restriction upon land use. This is a commercial property. It's a scrap yard, where people bring metals and refrigerators and just a whole host of things in order to sell them. And what has been happening for a drawn-out period of time is that some of the customers there start staging things out on the sidewalk, out on the street, in an attempt, I guess, to kind of speed up this whole process of scrapping metal. I have spoken with the manager there on a couple of occasions. We continuously get complaints from surrounding businesses as well. And as I said, this has been going on for quite some time. And so I did give them a time frame to correct it. It looks like they did, to the best of my knowledge, ceased the activity of the obstruction of the public right-of-way. But what I'd like to do is get a finding of fact in light of the fact that these violations tend to come and go. And so that's what we're requesting at this time, just a finding of fact.
When did the notice of violation require compliance?
Let's see. I believe the 22nd was the date for correction.
Of which month?
September.
And it was in violation after that, but complied?
Well, they were.
Well, you say it's coming. It recurs. It comes and goes.
Right. Exactly. Now, when I went out to do an inspection after the 22nd, they were fine. But that's not to say that it's still not occurring, because this has been occurring even when the previous code officer had this particular area. I do recall that he used to get a lot of phone calls and a lot of complaints with regard to. Is
that big green dumpster there regularly? Is that?
Yes, it is. And in fact, there's a couple streets down from this particular location. They actually staged those green dumpsters down at the end of those streets as well. They're dead-end streets, and those these green dumpsters have been staged down at the end of these streets as well. And once again, surrounding businesses have been complaining about this for quite some time.
Okay. All right, then in this case, I will find proper notice with the signed green card, and you also have posted the property. I will make a finding that the property was in violation, but complied after the deadline and the notice, and issue a finding of fact.
Thank you.
Number 11, CE 2009-0266, 3517 Windsor Avenue.
Good morning.
Morning.
Ray Leung, City of West Palm Beach, Code Compliance. 3517 Windsor Avenue was originally cited on 9/18/20 with the notice of violation posted at the property and City Hall on 9/28/20. Certified mail was sent to the owner's registered agent along with the property appraiser's mailing address on 9/22 of 20. Property was cited for 34102A inoperative vehicle and 78-1 obstruction of the city's right-of-way. No contact has been made with the owner. Special magistrate, this property came into compliance with all code sections after the compliance date of 10/7/20. Therefore, the city requests a finding of fact.
Thank you. I will find proper notice with the posting in the certified mail based on the evidence and testimony. I will find the property was in violation but complied, but that compliance occurred after the deadline required by the notice of violation. I will issue a finding of fact in this case.
Thank you.
Number 12, CE 200904333, 2701 Rosemary Avenue.
Ray Young, City of West Palm Beach Code Compliance. 2701 Rosemary Avenue was initially cited on 9/30 of 20, with the notice of violation posted at the property and City Hall on 10/2 of 20. Certified mail was sent on 10/1 of 20. Property was cited for 18106A, 18106B, and 18215B. No contact has been made with the owner, but 18106B was complied. All other code sections remain. Special magistrate, the trash and debris on this property poses a potential threat to the health, safety, and welfare of the community by being a possible haven for rodents, pests, vermin, etc. Therefore, the city requests 10 additional days to come into compliance or abatement.
And did you say the growth or the clean and sanitary compliant?
The trash and debris, the 18106A, which is yes, that has not complied. Only the 18106B, the excessive growth was cut.
18106B complied.
Yes.
Okay. Is this a vacant lot?
It is a vacant lot.
I see. All right, I will find proper notice in this case. I will find the property remains in I'll find the property complied with 18106B based on the testimony, but remains in violation of the other sections that were cited, clean and sanitary, and failure to comply. I will find that those violations constitute a threat to public health, safety, and welfare. I'll allow the respondent an additional 10 days to comply. Thereafter, the city is authorized to enter the property, abate the violations, and assess the costs.
Thank you.
Number 13, CE 200802466, 620 Avondale, Avenida Allegra.
Good morning, John Frosco, West Palm Beach Code. 620 Avenida Allegra was declared a chronic nuisance on August 21st of 2020, and the property was posted, the declaration was posted on August 24th of 2020, and certified mail was sent out, and shows that the certified mail was received. I did have contact with the owner, and he explained the situation, and we went back and forth, and he never submitted an action plan, and never cleaned up the property. At that point, the notice of hearing, notice of violation went out on September 23rd of 2020. Property was posted and certified mail was sent, but that was returned. To date, I have not received an action plan, and the city is asking the magistrate to formally declare this property a chronic nuisance and enter a service order, allowing for abatement services, cut and clean, board and secure, whatever is needed to keep the property code compliant, and all costs billed back to the owner of the property.
Is this occupied or is this vacant?
It's unoccupied. The building magistrate looks like it's demo worthy, and I did speak to the building department about the condition. And the owner in the communications said that he was working with the DEO, the Department of Equal Opportunity in Rebuild, Florida. And I've had emails back and forth with them, but they refused to give me any information, citing a public record law that it's proprietary, but it was a dead end. So that's
Okay.
where we're at with this. It's pretty bad property.
All right, well, I will find proper notice for this hearing as well as for the previous findings of chronic nuisance. I will uphold the city's declaration of chronic nuisance, authorize the city to provide chronic nuisance services to the property as requested, and assess those costs back to the property. I will sign that order.
Thank you.
Number 14, CE 2009034, 1033 18th Street.
John Frosca, West Palm Beach Code. This property was declared a chronic nuisance on September 3rd of 2020. The property was posted, same date, and certified mail was sent. I had a brief conversation with the owner of the property. He called, blamed it on his tenants, and I discussed what was needed to bring it back into compliance, and in the action plan, I did not get any. I then sent it to a hearing on September 23rd of 2020 and posted the notice of violation, notice of hearing, and no response. As of yesterday, the property is a filthy mess, and nothing has been done. So we're asking the magistrate to formally declare this a chronic nuisance, enter a service order allowing the city to abate for contract services at all costs billed back to the owner of the property.
Are all the windows boarded?
Yeah, that was based on the prior adjudicated case of noncompliance.
Okay. All right, I will find proper notice in this case based on the testimony and the evidence. The city's declaration of chronic nuisance is upheld. The city is authorized to provide all necessary chronic nuisance services to the property as requested, and the city is authorized to bill the cost of those services to the owner of the nuisance property.
Number 15, CE 20090098 Maddox Street.
John Frosca, West Palm Beach Code. That property was declared a chronic nuisance on September 9th, 2020. The property was posted the same date and certified mail was sent out. I sent it to an additional mailing based on a permit request for records, and I don't know if the person lives there or doesn't live there, or what happened, because the property was subsequently sold, but it appeared that the person lived there. So I sent it to two separate addresses trying to get the people to cooperate, and I did not. And so notice of a hearing, notice of a violation was sent out and posted on September 30th of 2020, and the certified mail was actually received on 10/3 of 20. To date, no action plan and no cooperation from the owner. The only thing that I saw that was done on the property is that they mowed the lawn and cleaned up a little in the front. So the city is asking you to formally declare this a chronic nuisance and enter a service order allowing the city to abate for city services not limited to cutting, cleaning, boarding, securing, or even towing junk vehicles.
Is that it there?
Pardon me?
Is that the junked vehicle right there?
Yes, it is.
Yeah. All right, I do find proper notice in this case. And based on the testimony and the evidence, the city's declaration of chronic nuisance is upheld. The city is authorized to provide chronic nuisance services to the property as requested and to bill the costs of any chronic nuisance services to the owner of the chronic nuisance property.
Thank you very much.
Number 17, CE 20080288 5501 Corporate Way complied. Number 18, CE 20090358 Temple Street.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On September 23rd, the open lot on Temple Street was cited for clean and sanitary, excessive growth, swells and parkways, and failure to comply. Property was posted October 1st, 2020. Certified mail was sent September 24th. Certified mail was returned September 29th. I've had no contact with the owner of this lot. City's recommending 10 days or abatement.
This is a vacant lot. That's really, really, really high grass. Okay, I do find proper notice with the posting and the returned certified mail. I find the property is in violation as cited, but that those violations constitute a threat to the public health, safety, and welfare. As such, I'll accept the city's recommendation I'll allow the respondent an additional 10 days to comply, but after that, the city is authorized to enter the property, abate the violations, and assess the costs.
Thank you.
Number 19, CE 20090083, 4801 Spruce Avenue.
Good morning.
Morning.
Christopher Thompson, City of West Palm Co-Compliance. Property at 4801 Spruce was cited on 9/9/2020. Notice of violation was posted on City Hall was at 9/9/2020. Certified mail was also sent on 9/9/2020. Property was cited for work without a permit, no rental license, no BTR or COU. Also unpaved parking and outdoor storage. As of yesterday, I have made contact with the homeowner, but the property was in compliance for the BTR, COU, and rental license, but they were not in compliance with the permits and unpaved parking and outdoor storage. City is requesting additional 30 days to come into compliance or $150 a day until compliance is achieved.
So the rental license, certificate of use, and business tax, they took care of?
Yes, sir.
But building permit?
Unpaved parking and outdoor
storage remain in violation. How many days did you recommend?
30 days.
30, thank you. I agree with that. I will find proper notice. I'll find the property remains in violation of City Code Sections 105.1, 94-482A, and 94-71C, but have complied with the other sections that were cited in the notice. I'll accept the city's recommendation, allow an additional 30 days for compliance, and thereafter daily fines of $150 per day until compliance is achieved.
Number 20, CE 20090090, 639 38th Street.
Christopher Thompson, City of West Palm Co-Compliance. Property at 639 38th Street was cited on 9/9/2020. Notice of violation was posted at City Hall on 9/9/2020, and certified mail was also sent on 9/9/2020. Property was cited for installation of fence without a permit or inspection. I have not made contact with the homeowner. The city is requesting an additional 30 days to come into compliance or $150 a day until compliance is achieved.
That's the fence that was done without the permit?
Yes, sir.
The wooden fence right there? Okay.
And the back as well.
Okay. Oh, I see. All right. All right, I will find proper notice in this case. I will find the property remains in violation as cited. I'll accept the city's recommendation for an additional 30 days to comply. Thereafter, daily fines of $150 per day will be assessed until compliance is achieved.
Thank you.
Number 21, CE 2009020872 38th Street.
Christopher Thompson, City of West Palm Co-Compliance. This property was cited on 9/16/2020. Notice of violation was posted to City Hall on 9/16/2020. Certified mail was also sent on 9/16/2020. This property was cited for unpaved parking and trash can placement. As of yesterday, I have not made contact with the homeowner, and the property is still not in compliance. The city is requesting additional 30 days to come into compliance or $100 a day until compliance is achieved.
Thank you. I will find proper notice with posting in the certified mail that's in the file. Based on the testimony and the evidence, I will find the property remains in violation as cited. I'll accept the recommendation for an additional 30 days to comply. After that, daily fines of $100 per day will be assessed until compliance is achieved.
Thank you.
Number 26, CE 20070254 801 South Olive Avenue, Unit 403.
Good morning, Officer Levine, City of West Palm Beach Code. This property was cited for failure to obtain a rental license and certificate of use. Service was accomplished by certified mail, which was signed for on August 10, 2020. On October 8th, I spoke with the front desk of this property, and they informed me that the tenant moved out on August 14, but the property is still listed for rent. So the city is requesting 30 days to come into compliance or $200 a day thereafter.
All right, thank you. I will find proper notice in this case. I will find, based on the testimony and the evidence, that the property remains in violation as cited. I'll accept the city's recommendation to allow an additional 30 days to comply, and thereafter daily fines of $200 per day until compliance is achieved.
Number 27, CE 20070277 801 South Olive Avenue, Unit 1415.
This property too was cited for failure to obtain a rental license and certificate of use. Certified mail was returned. The property was posted on 7/31/2020. On October 8th, I spoke to the front desk who verified that the last tenant moved out on August 31st, but the property is still listed for rent. The city is requesting 30 days to come into compliance with $200 a day thereafter.
All right, thank you. I will find proper notice in this case. I will find the property remains in violation as cited, accept the city's recommendation for an additional 30 days to comply, and thereafter daily fines of $200 per day until compliance is achieved.
Number 28, CE 20080067780 South Sapadilla Avenue, Unit 101.
This property too was cited for failure to obtain a rental license and certificate of use. Certified mail was returned. The property was posted on October 8th. Property on City Hall was posted on October 8th. And I also spoke to the front desk clerk who told me that the property is occupied. So the city is requesting 30 days to come into compliance with $200 a day thereafter.
Thank you. I do find proper notice with the posting and the returned certified mail. I will find the property remains in violation as cited, accept the city's recommendation, allow an additional 30 days to comply, and thereafter daily fines of $200 per day until compliance is achieved.
Number 29, CE 20080069651 Okeechobee Boulevard, Unit 201.
This property too was cited for failure to obtain a rental license and certificate of use. Certified mail was returned. Property was posted on October 8, 2020, at which time I also spoke to the front desk clerk who verified that the unit is occupied. City is requesting 30 days to come into compliance with $200 a day thereafter.
All right, thank you. I will find proper notice. I will find the property remains in violation as cited, and I will accept the recommendation for an additional 30 days to comply. Thereafter, daily fines of $200 per day until compliance is achieved.
Number 30, CE 20080224801 South Olive Avenue, Unit 428.
Rescheduled.
Number 31, CE 20090394526 Northwood Road.
Good morning, Joe Petrick, West Palm Beach Code Enforcement. This case in reference to a business operating without a business tax receipt or certificate of use. The property was issued a notice of violation via certified mail and posting on September 30th. The notice of violation gave the respondent 10 days to comply by obtaining a business tax receipt and certificate of use or cease operating the business. After notice violation was issued, our office received a letter from what appears to be the tenant disputing that a BTR or CO is needed. For the business, on Monday the 19th, I attempted to call the number on the letter, identified myself, and asked to speak to John Ellis, the individual who sent the letter. And I just heard some laughter, and then the phone was hung up. As of today, the property remains in violation of City Code Sections 82-144 and 22-32A. The city is asking compliance within 30 days or $100 a day fine be assessed.
Why did they think that they were exempt?
It appears to be a letter from a sovereign citizen group, from my experience with sovereign citizen groups. The letter is actually in the file, if you'd like to take a look at it. We did scan it and put it in. And the city attorney advised that she has a copy if you'd like to see it, sir.
Do you need a copy?
I have one, thank you, sir. It is, but it's okay. Yeah, Arlene's given Mr. Davis a copy.
It has more about the program, I don't know. But they charge, well, they just look at things online about them.
Right, Sarah at the CRA found a whole bunch as well. Sarah, I didn't send that to you, but yeah. Thank you so much, Arlene. Thank you.
Okay. I got it. All right, I do find proper notice in this case. I find, based on the evidence, that the property is in violation as cited, is not exempt. And I'll accept the city's recommendation for an additional 30 days to comply. Thereafter, daily fines of $100 per day until compliance is achieved.
Thank you.
Number 32, CE 20090395517 25th Street.
Joe Petrick, West Palm Beach Code Enforcement. This case is reference to a restaurant operating without a business tax receipt or certificate of use. A notice of violation was issued via certified mail and posting on September 30th and gave the respondent 10 days to either cease operating the business or obtain a business tax receipt and certificate of use. As the notice of violation was being written up and prepared to be sent out by the mail, I was contacted by one of the business owners. During our conversation, it was revealed that the BTR and COU was applied for on September 24th. She was actually calling in for an inspection for the business tax receipt and COU, but the restaurant has been operating since early September without proper inspections, tax receipt, or certificate of use. The restaurant owner requested an inspection on September 30th. I conducted the inspection. The restaurant was open and there was patrons inside, and it failed for some minor code violations. The restaurant employees were notified what needed to be corrected. On Friday, 10/16/20, I was contacted by Stacy, who stated she was helping the restaurant owners obtain the business tax receipt and certificate of use. We discussed how to bring the property into compliance, and it was a pleasant conversation, and she agreed that 30 days would be enough time to obtain the proper inspections, tax receipt, and certificate of use. As of today, the property remains out of compliance with code sections 2232A and 82144. The city is asking for compliance within 30 days or a $100 a day fine be assessed.
All right, I will find proper notice in this case, based on the testimony and the evidence. I'll find that the property remains in violation as cited, accept the recommendation for an additional 30 days to comply, thereafter daily fines of $100 per day.
Thank you.
Number 33, CE 20090399630, 14 North Flagler Drive.
Joe Petrick, West Palm Beach Code Enforcement. This case is reference to some large hedges and other vegetation that are not being maintained properly in front of a residence, a single-family residence, obstructing a sidewalk along Flagler Drive. And it's also partially obstructing a stop sign as well. The notice of violation was issued via certified mail and posting on September 30th and gave the respondent 10 days to comply by cutting the hedges so they don't obstruct the sidewalk or stop sign. I have not heard from the respondent. The property remains out of compliance with code section 94-446-2. Additionally, because it's blocking a sidewalk and blocking the stop sign, causes a safety violation concern, as Flagler's heavily traveled by pedestrians and bicyclists. The city is asking for compliance within 5 days, or a $250 day fine be assessed, and then is asking for an abatement order to clear the sidewalk and stop sign should the violation remain after 5 days.
All right, I do find proper notice in this case based on the testimony and the evidence. Property remains in violation of 94-446-2. I will allow the respondent an additional 5 days to comply. If the respondent does not comply, daily fines of $250 per day will be assessed until compliance is achieved. I will find in addition that the condition of this overgrowth blocking the stop sign and the sidewalk is a threat to the public health, safety, and welfare. I will authorize the city to cure those violations and assess those costs.
Number 34, CE 201000047, 414 27th Street.
Joe Petrick, West Palm Beach Code Enforcement. This case in reference to a property that has weeds and overgrowth to the rear of the property along the alleyway. A notice of violation was issued via certified mail and posting on October 8th and gave the respondent 10 days to remove the weeds and overgrowth. I have not heard from the respondent. As of today, the property remains out of compliance with code section 94-446-2. The city is asking for compliance within 10 days or a $100 a day fine be assessed.
Thank you. I will find proper notice in this case. I will find, based on the testimony and the evidence, that the property remains in violation as cited. I'll accept the city's recommendation, allow an additional 10 days to comply, and thereafter daily fines of $100 per day until compliance is achieved.
Thank you.
Number 35, CE 201000048, 427 26th Street.
Joe, that's yours.
I apologize. Strange. This should not have ended up on this agenda. Should have ended up on a next agenda. So can we withdraw this one?
Number 36, CE 200703833805, Paseo, Andalusia.
Good morning. I think there's two cases on this property, 36 and 38.
And 38?
38, yes. Two different case numbers.
Are they
Same property.
same?
Yes, same property.
You have the COU and business tax receipt under this case number.
Okay. So I'll do,
So how do you want to proceed?
okay. Officer Sonia Bin, City of West Palm Beach, Code Enforcement. This property was cited on September 1st. The notice of violation was posted on September 9th, and certified mail was sent on September 2nd. This property was cited for Code 18106A, 18106, 18162A, 2232A, 94402B, 2-5, 94482A, and 9471C. I have not made contact with the property owner. The property is still in violation of all codes except Code 94402B25.
The signage is in compliance, you said?
Yes, the sign complied, yes. The city is requesting additional 30 days to gain compliance or $100 per day until compliance is achieved.
I will find proper notice in this case with the posting and the certified mail. Based on testimony and evidence, I will find the property has complied with City Code Section 94402B.2-5, but remains in violation of the remaining code sections. I'll accept the city's recommendation for an additional 30 days to comply. Thereafter, daily fines of $100 per day will be assessed until compliance is achieved.
Yes.
So for 38, can we?
38? Yes. So, case number ending in 10, the property was cited for,
Did you cite the business on this one? Is that why it's two different ones? I'm just trying to figure out why there's two case numbers.
the reason why it's two case numbers is because the tenant is actually advertising a landscaping business at the residence.
On the 0010.
Yes.
Okay.
Yes. The property was cited on September 1st. The notice of violation was posted on September 9th, and certified mail was sent out on September 2nd. The property was cited for Code 2232A and Code 82144. The property is still in violation for both codes, and the city is requesting an additional 30 days to gain compliance or $100 per day until compliance is achieved.
All right, I will find proper notice. I will find the property remains in violation as cited. And I will accept the city's recommendation, allow an additional 30 days to comply. Thereafter, daily fines of $100 per day will be assessed until compliance is achieved.
Okay, number 37, CE 20080365838 Avondale, Hermosa.
Yes. So you've been City of West Palm Beach Code Compliance. The property was cited on August 31st, and the property was posted on September 9th. The certified mail was sent out on September 1st. This property was cited for Code 7434A1H, 105.1, and Code 9471C. I have made contact with the property owner. The property is still in compliance for all codes violation, and the city is requesting an additional 30 days to gain compliance or $100 per day until compliance is achieved.
And the permit was for that fence over there on
Yes.
the left side of the picture?
Yes.
Okay. All right, I will find proper notice in this case with the posting and the certified mail. I will find the property remains in violation as cited. I accept the city's recommendation for the additional 30 days to comply. And after that, daily fines of $100 per day until compliance is achieved.
Yes.
Number 39, CE 2009040823 Monroe Drive.
This property was cited on September 29th and was posted on September 30th. Certified mail was sent out on September 30th as well. This property was cited for code case 18215B, 18265, 18103E, and 18214B. I have not made contact with the property owner. The property is still in violation of all codes. The city is requesting an additional 10 days to gain compliance or obtain a boarding certificate or a bait to secure the property.
And this is vacant?
Yes, it's a vacant property.
All right, I will find proper notice with the posting and with the certified mail. Based on the testimony and the evidence, I'll find the property remains in violation as cited. I'll allow an additional 5 days for compliance. Thereafter, the city is authorized to enter the property. I do find that the unsecured property is a threat to the public health, safety, and welfare, and I will authorize the city to enter the property and abate those violations and assess the costs.
Number 40, CE 2009041223 Monroe Drive. Is this a duplicate?
Yeah, it's the same. It's two cases on the same property.
Okay.
Different case number. This property was cited on September 29th and was posted on September 30th. Certified mail was sent on September 30th as well. This property was cited for code case 18103B, 18106K, 7434A1H, and 9471C. I have not made contact with the property owner. The property is still in violation of code 18103B, 7435A1H, and 9471C. Code case 18106K was complied. The city is requesting an additional 30 days to gain compliance or $100 per day until compliance is achieved.
Did you say the outdoor storage complied?
The landscape complied,
Sorry.
not the outdoor storage.
18106K.
Yes, complied.
And on these, you're asking for 30 days and?
$100 per day
100.
until
All right.
compliance is achieved.
All right, I will find proper notice again with the certified mail and posting. Based on the testimony and the evidence, I'll find the property has complied with City Code Section 18106K, but remains in violation of the other sections that were cited in the notice. I'll allow an additional 30 days for the compliance. Thereafter, daily fines of $100 per day will be assessed until compliance is achieved.
Thank you.
Number 41, CE 200703945820 North Flagler.
City of West Palm Beach Code Compliance, Robert Watkins. This property was cited on July 23rd.
I'm gonna need you to a little more volume because I can hardly hear you. Yeah.
City of West Palm Beach Code Officer Robert Watkins. This property was cited on July 23rd. Certified mail was sent July 24th. Certified mail was received July 28th. This property was cited for 18106-A, 18-106G, 18-162-A, 22-32A, and 74-34A-1-J. Compliant violations are 74-34A-1J, 18-162A, and 22-32A. Remaining violations are 18-106A and 18-106G. I've had no communication with the representative from this property. I've sent email and phone call and haven't received a return on either one. The city is requesting 30 days or $200 per day after. And they have applied for the rental license, but I haven't gotten a call in reference to the rental inspection on any of the units. And that's what I sent an email and also called in reference to on this property.
So are you saying that that's still in violation, or that it?
Yes, sir, it is. It is still, because it's on hold right now until they have their inspection, and I've been calling and emailing to set that up. And as well as the pressure wash, painting, there's still areas of the property where there needs to be repainted. They pressure washed it, seemed, but it didn't help. It's still out of compliance.
So at 74, the garbage can placement it complied, but
Yes,
everything
yes,
else
that
is
has
still?
been complied.
Everything else is still in violation?
Yes, sir.
Gotcha. Let me see. All right, I will find proper notice in this case with the received certified mail. Based on the testimony and the evidence, I'll find the property complied with City Code Section 7434A1J regarding garbage can placement, but remains in violation of the other code sections cited in the notice. I'll accept the city's recommendation to allow an additional 30 days to comply. Thereafter, daily fines of $200 per day will be assessed until compliance is achieved.
Number 42, CE 20080341624 50th Street.
City of West Palm Beach Code Officer Robert Watkins. This property was cited on August 34th. Certified mail was sent August 31st. Certified mail was received September the 1st. This property was cited for 105-1, 18-103E, 18-106A, 18-106B, 18-106G, 34-102A, 74-34A-1J, 74-4B-1, 94-302A-4, and 94-71-C. Complied violations were 18-103E, 34-102A, 74-4-B-1, and 94-302A-4. Remaining violations on this property are 105.1, 18-106A, 18-106B, 18-106G, 74-34A-1, and 94-71C. The city is requesting an additional 30 days or $100 per day after. I've had no correspondence with the owner of this property.
What was the work that was done without the building permit?
In the back, they built, it seems to be spaces in the rear for them, their cars to go up under, like a tent, to say the least. It'll come up in the side pictures. Nope, we have to go back the other way. Nice there. And as well as the fence as well, they didn't have a permit for the fence that they put out front. They didn't, as well, it was the fence that was out front, and they built, they have a makeshift, looks like a carport in the rear, and they didn't have a permit for the fence that was in the front of property as well. Yeah, see if you go back to the last one. Yeah, see it back there in the back.
With the posts that are the same color as the house?
Yeah, they put the posts down and they used tarp to make like
I see.
carports in the rear. There's two of them.
I see. Okay. Okay, I will find, in this case, there is proper notice with the received certified mail. Based on testimony and the evidence, I will find the property remains in violation of City Code Section 105.1, 18.106A, B, and G, 7434A1J, and 9471C. I will find the property has complied with the remaining sections cited in the notice. I'll accept the city's recommendation for an additional 30 days to comply with the remaining violations and daily fines of $100 per day. After that, for each day, the property remains in violation.
Number 43, CE 20090002638 50th Street.
City of West Palm Beach Code Compliance Officer Robert Watkins. This property was cited on September the 1st. Certified mail was sent September the 3rd. Certified mail was received September the 8th. This property was cited for 18-106A, 18-106-B, 18-162A, 22-32-A, 74-34A-1-J, 78-6, 78-94C, 94-304-D-1-B, 94-442-C-1, 94-482A, and 94-71C. Compliant violations were 18-106A, 18-106B, 94-304-D-1B. Remaining violations are 18-162A, 22-32A, 74-34A-1J, 78-6, 78-94C, 94-442-C-1, 94-42A, and 94-71C. The city is requesting 30 days or $100 per day after.
All right, with the received certified mail, you have proper notice. Based on the testimony and the evidence, I will find the property has complied with City Code Sections 18106A and B, as well as 94304D1B, but remains in violation of all other code sections. I'll accept the city's recommendation for an additional 30 days to comply, and thereafter daily fines of $100 per day will be assessed until compliance is achieved.
Number 44, CE 20090082, 621 52nd Street, complied. Number 45, CE 20090086, 731 51st Street.
City of West Beach Code Officer Robert Watkins. This property was cited on September the 9th. Certified mail was sent September the 9th. Certified mail was returned September 26th. City Hall was posted October the 2nd. This property was cited for 26-35-B, 94-47B-1, and 94-71C. Compliant violations were the 94-71C. This is a repeat violation for outdoor storage. The city is requesting $100 per day on the repeat violation. In reference to the remaining on it, the city is requesting $20 or $100 per day after. I spoke with the tenant. He advised me that on Thursday he should be receiving the tag and registration for the vehicle to take it elsewhere. But until then, the recreational vehicle is still parked on the property.
All right, so the repeat violation is
Storage.
for the prohibited vehicle?
No, for the outdoor storage.
The outdoor storage. And when was the previous order? What was the previous case?
I didn't have that written down. Yeah, if you can. I didn't write it down. First Street. I think it was around July, but it might have been before. Yes, going to the.
When was the order finding violation on that one?
Go into the one back out and go into the lien law one. The one that says lien law. The second one down. The second one from the top. The next one up. No, not that one. Go to the next. No, the next one.
That's the notice, but where's, I need to see the order.
It should be like the, yeah, or the second from the last.
All right, that was for,
Second from the last. Go to the, mm-hmm.
9471C. Okay, and that was from 2019, September. Okay. And when did that come into compliance?
Get out of that. Mm-hmm. It'll be up on our phone. Yeah. No, back out. Yeah, October 30th. All right.
October 30th of 2019 it complied?
Back out of that. Back out of it. And go to where it says fines on the far right. To where it says fines. Yeah, go all the way over. No, just take the mouse over. See where it says okay. October the 30th is when it came into compliance for that.
And tell me again the date that the repeat violation was first observed.
It was August the 7th.
August 7th?
Yes.
All right. I will find proper notice in this case with the posting and the return to certified mail. Based on the testimony and the evidence, I will find the property remains in violation of 94-487-B1 and 94-71C. For 94-487-B1, I will allow an additional 20 days to comply, and thereafter daily fines of $100 per day until compliance is achieved. 94-71C is a repeat violation, which had previously been adjudicated in 2019 and complied in October of that year. Based on the testimony that this repeat violation was first observed on August 7th, I will assess daily fines of $100 per day starting on August 7th until compliance is achieved.
Number 46, CE 20090302436 51st Street.
City of West Palm Beach Code Officer Robert Watkins. This property was cited on September the 22nd. Certified mail was sent September 23rd. Certified mail was received September 28th. This property was cited for 18-106B, 26-35-B, 18-106M. Complied violations were 18-106B and 18-106M. This is also a repeat violation. The first repeat violation was in September the 18th, and it complied on October the 7th.
I thought you said that complied.
No, it was a repeat violation. The actual case was a repeat for the landscape. I didn't comply to 26-35B. I complied to 18-106B and 18-106M.
So is 18-106M maintaining the landscaping and 106B repeat violations?
Yes.
Okay. And then give me the information on the previous case, please.
It was in September the 18th. It's when it came, when I complied it, the very first case. September the 18th is when I cited it for the very first case that we took and it was adjudicated. And then it came into compliance on October the 7th of right now, when they actually did the work and cut the grass and did the landscape maintenance on the case that I have now that was written September the 22nd.
All right, so let me see the first case, the order finding violation, and the compliance affidavit. Then let me see the current case. Well, I see 18106B on this one. I don't see 18106M.
So it will be 18-106B for the repeat.
So 18106M is not a repeat?
No, just 18-106B.
And is 18106M still in violation? I thought you said it.
No, it's not.
That
It's
complied.
not. Mhm.
Okay. All right, what's your recommendation on 18106B?
It was $100 per day until it came into compliance.
When did you observe the repeat violation?
Say again?
When did you observe the repeat violation?
September the 18th.
September 18th? All right, with the received certified mail, I will find proper notice. Based on the testimony and the evidence, I'll find property has complied with 18106M. I'll find the property remains in violation of 18106B, that is a repeat violation which was observed on September 18th. I'll assess daily fines of $100 per day beginning September 18th until compliance is achieved. Yeah, do you want to go on to the 11:30 agenda?
Starting with other matter number 4, case number CE 10100267 Briggs Street.
And actually, I probably need to swear some people in. If you were not here this morning for the 9 o'clock agenda when everyone got placed under oath, and if you're going to be speaking to me about any of the matters on our 11:30 agenda, I do need to swear you in. If you'll stand and raise your right hand if you're going to be testifying. Do each of you swear or affirm under penalties of perjury your testimony today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. You can have a seat, or you can remain up at the podium for your case. For each of the cases, I'll get some background information from the city. And once I've received that, then I will come over to you and to hear what you have to tell me about your request. So with that, let's go ahead. I think we're on agenda item number 4.
Mitch Posner, Code Enforcement, Kate ending in 267724 Briggs Street, date ordered 11911, fine started 42111, ran for 540 days. Total $27,000, $50 a day, date of compliance 10/12 of 2012. It's a new owner. The only mitigating circumstances given is that they're a new owner. Purchased in 2011 for $37,000 for a 2-unit property. It's been rented since then. Appraised at $79,000. The city's asking for 25%.
So this is from back in 2010 and 11. This is an older. All right.
Yes, sir.
Thanks.
Cases from 2010.
Sir, when you start, please state your name and your relationship to the property.
I'm Stephen North. I'm part owner in the property as well as managing the property. As was brought out, when we bought the property, it already had an existing lien, so the offense wasn't ours, but we assumed it upon purchase. So all we're asking is leniency by the court.
Okay. This is the residence I'm looking at right now.
I don't think so. It might be a different color. We painted
There
it
was
this
actually a yellow house, a pale yellow house that I saw a minute ago. Well, tell me a little bit about the property. After you bought it, did you have to put any improvements into
We
it?
did. We met some citations. We put new windows in for thousands of dollars. Put new floors in. Of course, every property after they got foreclosed on needed to be updated.
Yeah.
So put probably $20,000 into the property just to bring it up to livable standards.
Is that it there?
That would be the hot property.
That one there? Okay. All right, anything else you'd like to tell me, sir?
Just be merciful.
Anything else from the city?
City thinks 75% reduction is merciful.
Okay. All right. Currently have a $27,000 lien, new owner. I'll reduce this to $3,000. How long will it take you to pay that?
I can write a check right now.
All right, I'll put 30 days on the order, but
Who
that would be
do I
great.
write the check to? City of West Palm? very much.
You're welcome.
Okay, other matter number 5 and 6 is the same address, if you want to call them together. Is that fine with you?
What address is that? What address is that?
I'll call it. I just didn't know if you wanted to call it together or not. It's 7620 South Dixie
Yes,
Highway.
together, please.
Case number CE 18120270 is other matter number 5, and other matter number 6 is case number CE 19020214, case address 7620 South Dixie Highway.
Okay.
As always, oldest case first. Case ending in 270, 7620 South Dixie Highway. Date ordered 3/6 of 19, fine started 7/5 of 19, ran for 340 days, total $87,000. $250 a day, date of compliance 6/17 of 20. Where is it? The applicant is the previous owner who caused the lien. They sold the property during this process. Case ending in 214, 7620 South Dixie Highway. Date ordered 3/6 of 19, fine started 7/5 of 19, ran for 348 days, $87,000 a total, $250 a day, date of compliance 6/17 of 20. As I stated, applicant is previous owner that basically caused the lien. The mitigating circumstances is that it was an estate. The owner had passed, and they didn't necessarily have access to the property or received the notice. The notice was sent properly to the address listed with the county, but of course, that person was no longer there to receive it.
Okay. What is the city's recommendation?
Considering the size of the two liens together, normal ask would be 25%. City's asking for 15%.
It is notable that there are two different cases from two different years, with different violations and the exact same lien amount to the penny. Not that that's here nor there, it's just interesting. Okay, yes, sir.
Good morning, Mr. Magistrate. My name is Mac Ross. I am an attorney with the law office of Kyle Felty, representing the applicant in this lien reduction. I also have with me Zachary Rothman, who is the applicant's probate attorney who handled all the underlying litigation for the probate, determining the actual true owner of the property.
Okay.
So I agree with what Mr. Posner said. I'd just like to emphasize, again, the applicant was not the owner. It was owned in the Eisler Trust, Joseph Eisler Trust. Joseph passed away, and the trust was subject to lengthy litigation to determine who the successor trustee was. So not only did our applicant not have notice, she didn't have the authority really to act until she was named the successor trustee to administer the assets of the trust, of which the subject property and the property that the notices were sent to are a part of. I'd also like to emphasize that as soon as our applicant became aware, she took immediate action. I believe she became aware when she tried to sell the property first in earlier this year, January 28th of this year, and we noticed it on the title commitment. And as soon as we saw that on the title commitment, our applicant, as well as their attorneys, we returned the contractor, and we sought to remedy these issues right away. The only other thing I would say, it's 2020. There were some delays to repairs, but those were all really a part of the litigation. She needed to get approval to release funds to make these repairs from the judges. Also, COVID. The contractor had trouble finding the right skilled labor and hiring the right skilled labor to get the jobs done. And then
A lot of municipalities, West Palm Beach included, permitting and stuff like that, working skeleton crews and remotely. It was hard to get the approvals needed. But as soon as they did, they went to work.
Okay.
So finally, just to reiterate, from the lien reduction application, points to consider when evaluating a lien reduction are whether the applicant owned the property. In this case, she didn't own the property while the fines were accruing. Whether she took proactive action. In this case, she didn't have the opportunity to, but if she had, she would have. And I think that's evident in the fact that she took immediate action right afterwards. Finally, the other specifics and hardships, like I said, were the trust litigation and limited access to the property, no access to the property. So we would ask today, really, that you would wipe the slate clean for our applicant. That's a significant burden to her, that amount, and we ask for leniency and understanding. And I'll ask if Zach has anything to add.
A few points, if I could, I with the council.
Yeah, come on up to the microphone so the record picks you up. Sounds like you got a good voice, but nevertheless.
Good morning, Zach Rothman. I'm with Boyce Freedom with Twitchick. My firm handled the underlying litigation. So there was 2.5 years. The decedent who owned the property died in 2017. And then there was 2.5 years of very, very contentious litigation where my client and another individual were claiming to be the successor owners. So during that time, there was no owner of the property. This property, along with the other trust property, was sitting idly. There was nobody who had access, nobody who could have any authority to manage the property. The notices here, I think importantly, were sent to the decedent's home, and during that time there was a squatter in the home, and my client and the opposing party had to bring an unlawful detainer action to get that person ejected. So there was no notice here, but what you can see is that immediately when my client became aware of the liens, she took immediate action and took it very, very seriously and did everything that she possibly could to come into compliance as fast as possible.
Okay, let me ask the city, the notice, do your records reflect it was sent to the address that was in the tax collector's
Yes,
records?
it's already been checked. Not disputing the fact whether or not it was an estate, but the estate is what was listed as the owner, and it was sent to that and that address. Whether or not they had a trustee responsible for that estate, the city bears no responsibility for notice on that. The other things, two things I'd like to point out is this actually failed the inspection to get to this hearing, and then they subsequently sold the property without fixing what it failed for $875,000. So yes, we do agree there should be a significant reduction, but not wiping the slate clean.
Okay, anything else, gentlemen?
Just to add to that, so substantial funds have been expended by my client already. All of this, we've gotten multiple court approvals to get funds released to bring the property into compliance. And like I said, it's been done as quickly as possible, but there's only been a very, very limited amount of time that's passed where my client has been the owner. There was nobody before who could have changed the address. There was no personal representative, no successor trustee. And had we known before, this would have been rectified much earlier. It's just the litigation tied everything up.
All right, thank you. All
Thank
good? Anything else?
We also, I believe we got an email from an inspector, Mr. Pasmino, that said we were in compliance for brought the property back into compliance.
If I could add one more point. So
yeah, you wouldn't be here if you weren't in compliance.
Right.
The email is talking about is for the case compliance to stop the fine. It was not the lien reduction inspection.
Okay.
What happened, Magistrate, if I could, is within days of getting this title commitment and becoming aware of the liens, we had retained a contractor and come more than 90% into compliance. It was really a paving permit that extended the process. Almost immediately, we were almost completely in compliance.
Okay.
The city disputes none of that. We only dispute any characterization of notice as improper.
All right. We have two cases one from 2018 and one from 2019. Different violations, but they're all basically property standard issues. Each case has an $87,000 lien on it. I'm going to reduce both of them, or each of them, to $8,700. So whatever that comes up to, it comes up to, but basically, the city's recommendation was a 15%. I'm going down to 10%. How long will it take you to pay that?
You said how long will it take?
Yes, sir.
I think we just need to get court approval, so we should be able to do that within 2 weeks conservatively.
Put 30 days on the order. I don't want you bumping up against any deadlines. Okay.
Thank you very much.
Is there any possibility they would have a problem and need 60? I mean, the city has no objection to that. I just don't want to get it hung up where it wasn't paid on time because.
Yeah, why don't we put 60 days on the order just to be doubly sure? I think that's a good idea.
We'll get it done as soon as we can, too.
Thank you, Mr. Magistrate. Thank you, Mitch.
Thank you.
Other matter number 1, CE 09030503, 801 Division Avenue. And other matter number 2, same address, CE 08100105. Number 3 is the same owner as well.
Good afternoon. Good afternoon. And whenever you're ready.
Okay, I didn't hear, did you call 2 cases or 3?
I called 1 and 2, and then I just stated that other matter number 3 is the same owner.
Okay, yeah, it's all the same owner. Can we do all 3 at once, sir?
Okay, do you want me to call number 3?
Oh, so I
The
think
magistrate
number
is
3
willing,
the
yes.
same owner, but different property.
Yeah.
Let's
Correct.
do 1 and 2 together, and then,
Okay.
well, I mean, I guess you can present them all. It's
They're all the same
it's all the
applicant.
same people, so.
Right.
Okay, other matter number 3 as well. Case address 1548 6th Street, case number CE 08110359.
Okay, first magistrate, it's an atypical case, actually the first one I've had of its nature. These properties were foreclosed,
Okay.
and the lien was no longer applicable to the property, just to the owner at the time. The applicants are those owners.
Okay.
So I've never actually had to present one of those before. Case ending in 503, I'm sorry, wrong one first. Case ending in 105, 801 Division. Date order 12/3/08, fine started 3/10/09. Ran for 328 days, total $16,450 a day. Date of compliance 2/1/2010. The applicant is the owner that caused the lien. Property was foreclosed in 2011.
Okay. So 801 Division was the one that was foreclosed?
They were both foreclosed. I didn't get to the other one yet, though.
Okay.
The second case on 801 Division ending in 503. Date ordered 7/15/09, fine started 9/14/09. Ran for 799 days, total $59,925, $75 a day. Date of compliance 11/22/11. The facts remain the same. The mitigation, of course, is they had financial difficulty at the time, and the properties were foreclosed on. City would like to point out that they actually, at this point in time, own 3 investment properties. So the city only has so much forbearance on these liens when they still own 3 investment properties. City's asking for 50% on all of them. For 801 Division, there were 17 cases under their ownership. There were never responses, just most of the cases were abated. We basically were dealing with an absentee landlord and a city-managed property. Moving on to the other property, case ending at 359, 1548 6th Street, date order 2/18/09, fine started 3/23/09. Ran for 26 days, total is $2,600, $100 a day, date of compliance 4/18/09. Same thing, the applicant caused the lien at the time. It was foreclosed in 2013. The city's asking for 50%.
Okay. maybe I'm not understanding. If these were all foreclosed out, what are we?
They were foreclosed to the point of the liens were no longer applicable to the property, only to the person the lien was against. So the property was sold without the lien attached to it, only the lien is only applicable to our applicants. Arlene, could you possibly explain this better? I only know layman's terms.
Yeah, I'm sorry, I'm being dense.
No, no.
Just not.
So this is 801 division. Proposed control. I'm sorry, my hand is
No,
like.
you're-
This lien is proposed as the 801 division, but remains enforceable against all other real property owned by James and Dean Weasley.
Right.
That's that one. And that's that one as the 801 division.
Okay. So there's other property besides these three that the respondents own that they could attach to.
That's the way we're looking at it.
Okay.
Okay.
No, I think that's what the law says, is that it applies to anything that the respondent, okay.
Right.
But it doesn't apply to 801 division or 1548 sixth anymore. But if,
Yes, sir.
But if there's other property that's owned.
Yes, sir. It would cross
Could
attach.
attach to those.
Right.
And then the city could proceed against those other properties, whatever they may be.
Okay, I've got the pop-up sheets for both, if you want those, and a pop-up sheet for each of the investment
I
properties.
guess I'll take them, but I don't know, if in this case, the value of the property is kind of irrelevant since they were foreclosed. Yeah, okay. Okay. So there's these other properties on Grant Street.
The other two are in Riviera Beach. One on Grant and two in Riviera Beach.
Okay. All right. Now I'm legally caught up.
One thing, Magistrate, I may have misspoke, they would have to answer. I think one of the Riviera Beach properties is actually their residence, not an investment property, is that correct? Okay, so there's only two investment properties and then their residence in Riviera
Okay,
Beach.
let me hear from the applicants. Good afternoon, folks.
Good afternoon.
Good afternoon, Special Magistrate. I'm James Easley. This is my wife.
I'm Gail Easley.
Hello.
So it's James Easley, husband and wife. Fact of the matter is, during the economic downturn, we unfortunately lost our primary residence to foreclosure. The property at 801 Division, we had already, we were we had a subprime mortgage that was very, very unfavorable terms. We tried to talk to the bank about it. We reached what we thought was a resolution, and we told them, and they understood that they were taking possession of the property and we were moving out. We could no longer afford the terms under the conditions that we got that mortgage. Very unfavorable terms. We were able to find another home in the city, very favorable terms that we thought at the time before both of us lost our jobs. She had been employed with FPL for about 15 years. I was a director of a contractor program on one of the school campuses, middle school campus. The grant and the funding for that went away. So both of us lost our jobs at the same time. The only people that have had access to 801 Division when we moved out were investors, squatters, and the bank. All right, there's a list pendants that was filed on both of these properties. It's our contention that because that list pendants was filed on the 801 Division property and on the 1548 6th Street property, that the bank should have been notified. The city should have notified the bank, and all of those conditions that existed on those properties should have been taken care of. Any fines or liens as The inspector just stated, it's the first time he's presented a case like this. It's the first time we've ever heard of anything like this. The fines are usually attached to the property. Usually when there's a list pendants, that's the point of the bank filing the list pendants to notify all parties that there is a pending litigation, that they were in the process of foreclosing on the property. And if they never received notice, if the city never notified the bank who were the primary lien holders, and those properties have sold multiple times in the past 10 years or so, 10 years plus since we've had possession. You know, the property that we live in now, and the property that was referenced in the city, these are properties that we purchased a couple years ago, maybe one this past year and the other one the year before. You know, these cases go back over a decade that have been sold multiple times to multiple investors. The only people that have access to these properties in that time has been the investors, have been squatters at the property, and the bank.
Okay.
If I can ask a question, Magistrate?
Yes, sir.
This is the first time I've heard any mention of the list pendants. Can you say when that was filed?
Well, yeah, I only have access to what the city has access to. And according to court records, it states one of the list pendants filed at the property was in, one is on 2010, one is 07. Again, inspectors already stated, as a matter of fact, that we did lose both of these properties to foreclosure. Again, we both lost full-time jobs that we were at for years and years. We could no longer afford it. We tried to work out something, were unable to stay, unable to pay. So we had to regroup and rebound. The bank did their part. They filed the list pendants. They went through with the foreclosure. It was we were under the impression that once we negotiated everything with the bank, we were negotiating deed in lieu of foreclosure. We tried to do cash for keys. We were trying to look for any remedy that we could find to be able to make sure that we stayed in constant communication with everybody. Even the notes that the city has, it says that, you know, we came in and we spoke to them. We let them know exactly what was going on, and still, for some reason, they were never notified. The list pendants was never filed, and even now on record, they still haven't contacted the bank. That's who should have paid anything that's due to the city. We have nothing to pay to the city, and we would like a special magistrate in lieu of this being special circumstances to render this case closed and no fines or liens be paid. Thank you.
So, what is your, so you, 1124 Grant, what is that to you?
Excuse me?
1124 Grant Street.
Yes.
What is that where you're living now?
Yes.
Okay. And then what about the 124 West 13th Street and the 348 West 14th Street in Riviera Beach?
348 West 13th Street, our daughter, when she finished school in Tallahassee a couple years ago, she decided to move back, and we were able to get that property for her to be able to live. Our credit wasn't at a place that we could purchase it with a mortgage. We were able to get it. The primary owner of it did an owner financing. Brings tears to my eyes because he did us a huge favor. He owned it outright. He did owner financing on it, and we were able to get that for our daughter. She didn't want to come back home and live with her parents anymore, but she did want to come back home, and so we were blessed to be able to get that for her.
Okay. And then what was about the other one?
124 West 13th Street. It was, as you can see, it was in the Life Center of Palm Beach County. That's the church we attend. We had an assisted living facility there. for the last, since probably like the last 8 years. And the owner of the assisted living facility actually decided that they were retiring. And so their license was expiring. And so what the church did was they signed it over to us as board members to be able to get the license, to be able to get it established as an assisted living facility, but in a new owner's name as the church.
Okay. All right, a lot of information, I appreciate that. Anything else from the city on these cases?
The only thing unusual about this case is that it proceeded to a lien reduction hearing. It is not unusual at all for foreclosed properties, the liens to still be applicable to the owner at the time of the lien and any other property they own.
Right, no, I understand.
Okay, the way he was characterizing it, I just didn't want it on the record that.
Again, I apologize for being legally slow at the beginning of the presentation.
Well, I'm a layman, so I wasn't explaining it properly. But yeah, it's actually very common. The unusual part was that it proceeded to this hearing. Notice at the time of the case is Liz Pendants or not. It was not, the address was never changed. The ownership was never changed until the dates on those papa sheets. Notice was due and proper. The bank was not yet responsible for those properties.
Let me ask a question. Sometimes when we have a list of cases like this, I'll wipe them out on the smaller ones and just deal with the larger number in terms of, to make your record keeping. But in this case, there's different addresses, so.
That's probably best separate with different addresses.
So that was what I figured, but I thought I'd ask anyway. Okay. All right, anything else, folks, before I try and come up with something that...
It is standard practice for the city's code compliance division to notify the list pendants. That's common practice in the city. Even in the inspector's notes regarding the code case, they realized that the property was foreclosed, and at no point did they ever notify the rightful owner of the property at the time of the transaction, which was the bank.
Okay.
Sir, on the code supervisor and what he's calling common practice, I rarely come across it.
I have a document that I printed from the one-stop shop, the eGov Plus. Back in 2011, it says that one of the inspectors noted in the case log that the property was owned by the lender. And so, again, that was nearly 10 years ago.
Okay, thank you. So, having heard everything from everybody.
Can I ask one question? My question is, like, when it lists the status of the case, what does CC stand for? Charlie.
Closed complied.
So that's probably a code enforcement division case number designation or something.
It's a case status. CC would be closed/complied. One of these cases does mention that there had been a foreclosure, but the mention of that, as he said, is in 2011, but it wouldn't really have much bearing on a 2008 case. Not at that point.
Okay.
And what for 801 division, what is the case number? I'm sorry.
There's two cases. Which one are you? I don't know which one you're asking about.
What are the case numbers?
CE 08100-105 and CE 0903-0503.
Anything else, folks?
Yeah, because I have a I have because the same section code is referenced with a different case number as being complied.
Magistrate, as I stated on the case history, there were 17 cases on this property under their ownership. As there's only 2 liens, the other 15 would have been closed and complied.
Okay. All right. This is an interesting one for sure, and I'm going to reduce these more than the city would like, but not as much as you would like, and as is often what I do. But in the 801 Division Avenue, there's 2 cases. The 2009 case has a $59,925 lien. I'm going to reduce that to $2,000. The 2008 case has a $16,400 lien. I'm going to reduce that to $1,999. And the lien on the case at 1548 6th Street, I'm going to reduce to $1. So that's a total of $4,000. How long will it take you to pay that? I can give you up to a year. And please don't ask me to reduce it more. That's what I feel is appropriate, but I'm willing to give you as much time as you reasonably need. Just why don't you put 12 months on the order to pay that? 12 months. Okay.
Thank you, Special Magistrate.
Thank you very much.
Thank you to the city.
Thank you.
Does anybody need a brief recess, or do you want to push through? We've only got about 20 more cases. Okay, let's do it.
Number 47, CE 20090066 Bunker Ranch Road.
Let's go. 47, 48, and 49 is complied, and 50.
Are complied?
Yes, 47, 48, 49, and 50 has complied.
I'll just call them with the case number and address. 48 CE 20090068 809 Hanson Street complied. Number 49 CE 20090097 829 Green Street complied. And number 50 CE 20090127 815 Green Street has complied. Number 51 CE 20090132 5801 Churchill Circle East.
Richard Pasmino, Code Enforcement Officer for the City of West Palm Beach. This property was cited September 10th, 2020. Certified mail was sent September 11th and received September 12th. In addition, the property and City Hall were posted on 9/15/20. This property was posted for inoperative vehicle, obstruction of the right-of-way for the sidewalk, and unpaved parking at the property. As of yesterday, the only violation that is in compliance is 78-1. They moved the vehicle more onto their property off of the sidewalk. I've had no contact from the owner of the property, and the other 2 violations remain. The city's asking for 10 additional days for this property to come into compliance, or the city's asking for a $100 a day fine until compliance is achieved.
All right, I will find proper notice in this case. I will find property remains in violation as cited, except it complied with 78-1. I'll accept the recommendation for an additional 10 days to comply with the outstanding violations, and thereafter daily fines of $100 per day until compliance is achieved.
Number 52 CE 20090295 413 Plymouth Road.
Richard Pasmino, Code Enforcement Officer, City of West Palm Beach. This property was cited September 22nd, 2020. Certified mail was sent September 23rd, and the property and City Hall were posted on September 28th. This property was cited for 18106A clean and sanitary conditions, excessive growth, failure to comply, hurricane hazard, trees, hedges obstructing right-of-way, and clean up to the center of the right-of-way. I spoke and met with the property owner. I met with him yesterday at the property. Has started work trying to comply with the violations. As of yesterday, the only violation he has complied is 74-4-C-4. The rest of the violations are incomplete. The biggest problem is the tree is in the power line. When I met with the property owner, he's having issues. He doesn't have the resources to have a professional up in the power line to, properly and safely fix the violation. They have some type of tree where it pretty much takes up the whole backyard. It has like some really crazy roots. It'll pop up. So the neighbor that shares that alleyway is complaining. Her power and his power are the only two that are connected to that that line.
Yeah.
And every time a storm comes, it'll knock out both of their power. So that's what the tree looks like, and it takes up pretty much his whole backyard. And like I said, he doesn't have the resources to get it properly done. I invited him to come to the hearing to see what time frame he would try to get, but he didn't show up, and he has no no resolution. The city's asking for 14 additional days for him to comply with the violations at the property, or the city is asking for an order to abate the violations, since it's a health and safety issue.
I will find proper notice in this case. We'll find the property remains in violation as cited, except that 74-4C4 has complied. I'll accept that recommendation. This is certainly a health, safety, and welfare concern. I will allow the respondent 14 additional days. Looks like we've made it almost to the end of storm season, so. But still, the city will be authorized at that point to enter the property, abate these violations, and assess the costs.
Thank you.
Number 53, CE 20090220 3818 Greenwood Avenue.
Good morning, Natalie Clark with the City of West Palm Beach Code Compliance. 3818 Greenwood Avenue was cited on 9/16/20. The property and City Hall were posted on 9/17/20, and certified mail was sent on 9/17/20. The property was cited for 105.1, 110.1, 94-482A, 9471C, and 94-487B1. The property has since not 94-487B1. I do apologize. It's 105.1, 110.1, and 94-482A, and 9471C. The property has since complied with 94-482A. The city is asking for a split order for code sections 105.1 and 110.1. The city is asking for 60 additional days or $200 per day. For code section 9471C, the city is asking for an additional 10 days or $100 per day.
All right. The outdoor storage is more than just the driveway pavers, right?
The outdoor storage, there's a picture of construction debris in the back. It's a lot of concrete that's just stored sort of like in the rear, but you can see it from the street. It's not that, it's right there.
Oh, all of that? Oh,
Correct.
I see. Yep. Okay, I do find proper notice in this case. I'll find the property has complied with 94-482A, but remains in violation of the other sections cited in the notice. For 105.1 and 110.1, I'll allow an additional 60 days to comply, and thereafter daily fines of $200 per day will be assessed for each day those violations continue. For 9471C, I will allow an additional 10 days to comply, and there will be daily fines of $100 per day for each day beyond that those violations remain.
Number 54, CE 20090255942 43rd Street.
Natalie Clark, City of West Palm Beach Code Compliance, 942 43rd Street was cited on 9/18/20. The property and City Hall were posted on 9/22/20, and certified mail was sent on 9/21/20. The property was cited for 18-162A, 22-32A, 94-273-D-31-B-3, and 94-487-B1. The property has since complied with 94-487-B1 and 94-273D-31B3. I've had contact with the property manager. The city is asking for 30 additional days or $200 per day for code sections 18-162A and 22-32A.
All right, I will find proper notice. In this case, I will find the property remains in violation of sections 18-162A and 22-32A, but has complied with the other sections cited in the notice. I'll accept the city's recommendation to allow an additional 30 days to comply. After that, daily fines of $200 per day will be assessed until compliance is achieved.
Number 55, CE 20090428912 44th Street.
Natalie Clark, City of West Palm Beach Code Compliance, 912 44th Street was cited on 9/30/20. The property and City Hall were posted on 10/1/20, and certified mail was sent on 10/1/20. The property was cited for 34-103B. I've had contact with the owner. The city is asking for an additional 30 days or $100 per day until compliance is achieved.
Is it the vehicle that's on the cover, or the?
Yes, it doesn't have any front wheels on it, so it's kind of like on stilts.
Oh, I see. Yep, yep. Okay, I will find proper notice. I will find the property remains in violation as cited, accept the city's recommendation to allow an additional 30 days to comply. Thereafter, daily fines of $100 per day will be assessed until compliance is achieved.
Number 56, CE 2009043 1041 45th Street has complied. Number 57, CE 2009041 4802 East Avenue has complied. Number 58, CE 2010031 814 42nd Street.
Natalie Clark, City of West Palm Beach Code Compliance, 814 42nd Street was cited on 10/2/20. The property and City Hall were posted on 10/8/20, and certified mail was sent on 10/5/20. The property was cited for 34-102B and 94-71C. The property has since complied with 94-71C. The city is asking for an additional 10 days for code section 34-102B or $100 per day until compliance is achieved.
Is it that black Excursion? Is there no
Correct.
tag on it?
Yes, and so instead of correcting the violation, they just turned it around, so the violation still remains.
Gotcha. All right, I will find proper notice. Based on the evidence, I will find the property remains in violation of City Code Section 34-102B, has complied with 94-71C. I'll allow 10 additional days to cure the outstanding violation. Thereafter, daily fines of $100 per day will be assessed until compliance is achieved.
Number 59, CE 2010039 4106 North Terrence Drive.
Natalie Clark, City of West Palm Beach Code Compliance, 4106 North Terrace Drive was, give me 1 second, I do apologize. I do apologize, Special Magistrate. Okay, 4106 North Terrace Drive was cited on 10/2/20. The property and City Hall were posted on 10/8, and certified mail was sent on 10/13. The property was cited for 94-487B1 and 94-71C. The property has since complied with 94-487B1. The city is asking for an additional 10 days or $100 per day for code section 94-71C. I've had no contact with the property owner.
Okay. I do find proper notice. Based on the testimony and the evidence, I do find the property remains in violation of City Code Section 9471C, but has complied with City Code Section 94-487B1. I'll accept the city's recommendation to allow an additional 10 days to comply. Thereafter, daily fines of $100 per day will be assessed until compliance is achieved.
Thank you.
Number 60, CE 200603482008 Ponce de Leon Avenue.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. This property was cited on August 4th. Property and City Hall were posted on August 17th. Certified mail was signed for on August 8th. I've had contact with the property managers through phone call and email. The property was cited for 1813E, 1813I, and 1816A. Magistrate, I'm not sure if they're in compliance. The tenant that was in the unit, she has moved out, and they have not contacted me to let me know what has been done. It was an issue with plumbing, and I know it was affecting other units, but I have not been given access back to the property. So at this time, the city is going to ask for an additional 60 days or $200 per day until compliance is achieved.
Okay. So you have evidence of the violations, but you have not.
I'm just not sure if it's been complied or not.
Not been called back to
No.
inspect for compliance. Okay. All right, I'll find proper notice in this case. Based on the testimony and the evidence, I will find property remains in violation as cited. I'll accept the city's recommendation, allow an additional 60 days to comply. Thereafter, daily fines of $200 per day will be assessed until compliance is achieved.
Number 62, CE 200801221486 North Mangonia Drive.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. This property was cited on August 11th. Certified mail was signed for on August 13th. The property and City Hall were posted on August 12th. I've had contact with the property owner. Property was originally cited for 1813J, 7434A1J, and 94482A. Property has complied with 9482A. At this time, the city is requesting an additional 60 days or $50 per day until compliance is achieved.
Okay, I do find proper notice with signed certified mail. I do find property remains in violation with 18103J and 7434A1J regarding exterior paint and garbage can placement, but has complied with 94-482 regarding the parking requirements. I'll accept the city's recommendation, allow an additional 60 days to comply. After that, daily fines of $50 per day will be assessed until compliance is achieved.
Number 63, CE 20080213 21st Street.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. This property was cited on August 18th. Certified mail was signed for on August 21st. The property and City Hall were posted on August 24th. I've had contact with the property owner. Property was cited for 1816A, 1806B, 74-4C5, and 94-482A. At this time, the city is requesting a split order, 10 days for 94-82A or $50 per day. And for the remaining violations, we ask for 3 days or abatement.
I will find proper notice with the signed certified mail. Yeah, I do find the property remains in violation as cited. I'll accept the recommendation for the split order. I'll allow 10 additional days to comply with 94-482A, or there will be daily fines of $50 per day thereafter. For 18106A and B and 74-4C5, I do find that clean and sanitary excessive growth all the way out to the center of the right-of-way constitute a threat to public health, safety, and welfare. I'll allow the respondent 3 additional days. Thereafter, the city is authorized to enter the property, abate those violations, and assess the costs.
Matter number 64, CE 20090237 1924A East Isaacs Avenue.
Cassandra St. Hilaire, Code Enforcement Officer for the City of West Palm Beach. This property was cited on September 17th. Certified mail was sent on September 18th. The property and City Hall were posted September 24th. I've had no contact with the property owner. Property was cited for 1816B, 18162A, 1816A, 2232A, 74-4C4, 74-4C5, and 482A. At this time, the city's requesting a split order. 3 days, an abatement for code sections 1816B, 1816A, 74-4C4, and 74-4C5, and an additional 30 days for code sections 18162A, 2232A, and 482A, or $200 per day until compliance is achieved.
30 days and how much?
$200 a day.
Thank you. All right, I will find proper notice with the certified mail and the posting in this case. Based on the testimony and the evidence, I find the property remains in violation as cited. I'm going to allow 30 days to comply with sections 18162A, 2232A, and 482A. And if compliance is not achieved within 30 days, daily fines of $200 per day will be assessed until compliance is achieved. For the remaining violations, I find the excessive growth, clean and sanitary, and the right-of-way obstruction and waste to constitute a threat to the public health, safety, and welfare. I will give the respondent 3 additional days to comply. After that, the city is authorized to enter the property, abate those violations, and assess the costs.
Number 65, CE 200902449, 22nd Street.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. This property was cited on September 18th. Certified mail was sent out also on September 18th. The property and City Hall were posted September 24th. Property was originally cited for 1816A, 1816B, 18215B, 74-4C3, 74-4C4, and 74-4C5. I've had contact with the property owner. At this time, the city is requesting an additional 3 days or abatement.
This is a vacant land?
It's vacant lots in the residential area, yeah.
That's a mess. Okay. I do find proper notice with the posting and certified mail. I will find the property remains in violation as cited, and I will find that those violations constitute a threat to the public health, safety, and welfare. Give the respondent 3 additional days to comply. After that, the city is authorized to enter the property, abate the violations, and assess the costs.
Number 66, CE 20090256711, 22nd Street.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. This property was cited on September 18th. Certified mail was received on September 23rd. The property and City Hall were posted September 24th. I've had contact with the property owner. The property was cited for 1816A, 1816B, 18215B, 74-4C3, 74-4C4, and 74-4C5. At this time, the city is requesting an additional 3 days or abatement. They're right next to each other, these next 2 lots.
So the pictures look strikingly similar.
Yeah, right next to each other.
All right, I do find proper notice. I do find the property remains in violation as cited, and those violations constitute a threat to public health, safety, and welfare. I will allow the respondent 3 additional days to comply. After that, the city is authorized to enter the property, abate the violations, and assess the costs.
Number 67, CE 200902259, 22nd Street.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. This property was cited on September 18th. Certified mail was signed for on September 22nd. The property and City Hall were posted September 24th. I've had no contact with the property owner. Property was cited for 1816A, 1816B, 18215B, 74-4C4, and 74-4C5. At this time, the city is requesting an additional 3 days or abatement. Again, they're right next to each other.
This is another one, right?
Yeah, it's 3 of them right next to each other.
All right, I'm going to make the same findings. I do find proper notice. I find the property remains in violation as cited, and that those violations constitute a threat to public health, safety, and welfare. I will allow 3 days for the respondent to comply. Thereafter, the city is authorized to enter the property, abate the violations, and assess the costs.
Thank you.
Is that it? All right, it's 1:45, 12:44 p.m., and we stand adjourned.